May I have your lordship's kind leave to mention this matter? This is an extremely urgent matter. The reason being, the person happens to be a 69-year-old man. He preferred an application under Section 23 of the Maintenance and Welfare of the Senior Citizen Act before the concerned SDO at Hon'BLE. The application was preferred way back in the month of January 2025. Now, till date, no decision has been taken. Now, my son is planning to sell the property. This is the difficulty, my lord. Once he sells, it would create a lot of ambiguity, my lord, owing to the same. Humbly beseeching your lordship to take this application because nothing has been done by the SDO.
No, but then the matter is there in the list.
No, my lord, I'm seeking your lordship's leave to, my lord.
Leave to file.
My lord, difficulty is once he sells the property, it would create a lot of ambiguity.
You file it in the
My
department.
lord, kindly consider this, my lord. Once he sells it, because my lord, he had already taken out the query. I have already have information from the local registry office, my lord. That is the difficulty. Once he sells it out, my lord, it will create a lot of difficulties.
What is the difficulty that you are apprehending? Third party rights will be created?
Yes, my lord, because once he sells it,
Property is the father's property?
it's his father's property, is a conditional deed. The deed was made out of legitimate hope and expectation that he would look after. It's written there in the deed. Now, soon after the deed was registered, he and his wife had been ousted from the property.
Very well, leave. Wednesday it will appear.
I'm deeply obliged.
May I have your lordship leave to mention, my lord, this matter, kindly have a look. Paragraph number 3 and 4, my lord, in the order sheet, it is written that date 26 July, it should be 26th August, and kindly have a look to this order.
Okay.
By mistake, it is written 26th July. Para 3 and 4.
All right. To be mentioned.
May I have my lord's kind leave to mention 1760 of the month list, my lord. This is a hearing matter, my lord. It was mentioned before your lordship, and my lord is not taking hearing matter, my lord. That is the reason I have mentioned the matter before the Honorable Chief Justice. And my lord, Chief Justice requested me to mention again before your lordship. It's a tender matter, my lord. The NIT was published without following the CVC rules, my lords. And my lord, the particular tender has not been published in GEM even, my lord.
In GEM.
GEM.
All right.
And that is the challenge of the matter, my lord. And the work order is issued already, my lord. That is required to be set aside, my lord.
What is the item?
My lord, 1760.
Why did you not mention at the time of the upgradation of matters?
Lord, I have earlier occasion I have mentioned, my lord, but not this time I have.
Yes, then why did you not mention? Come on the day when mentioning is taken up.
Mentioning for a non-prosecution.
May I have your lordship's leave to mention a matter, my lord? My writ petition was dismissed for default, my lord. We had mentioned, my lord had indicated to file an application for restoration. We have done that, my lord. The urgency is, my lord, the
Restoration, it was your fault.
my lord.
Take the responsibility.
My lord, may kindly appreciate, my lord.
Lordship's
The
kind
district
leave
magistrate
to mention
has refused to provide police help in surfacey proceedings, my lord.
Yes.
Can he do that, my lord?
That is the merit of the matter.
My lord, may kindly.
Your responsibility was to ensure that the matter, that the learned counsel remains present when the
My
matter
lord,
is called. What can be done?
My lord, it was listed at, it was called at 429, my lord, on a monthly list and it was rejected. We were coming to court, my lord.
What
It's
can
our
be
fault,
done?
my lord. My lord, may kindly only restoration application, my lord, had indicated.
It will appear in the list in due course. Yes.
Your lordship's leave,
No,
it's a
don't
petition, we seek to move urgently before your lordship. But the urgency is the petitioner is a tender, a successful tenderer working in a government hospital. Now, the tender document stipulated that the billing cycle would be monthly. But I am working since October 2024. But till date, my bills has not been processed due to a minuscule error on the part of the tendering authority. The difficulty is if the bills are not processed, out of funds, my workers has not been paid, and I may be blacklisted for the subsequent tenders. If your lordship kindly accommodate us for any day subject to your lordship's convenience. Any day subject to your lordship's convenience.
No, I understand, but then why not in the department?
But the difficulties
from October, the bills are unpaid. We are in July.
Now the workers are saying that we will not work for you anymore because we are,
Obviously, they will not work if you pay them, do not pay them, why will
I'm
they
not
work?
getting paid by the government authority only. The difficulty is
Next Friday under the heading payment of dues.
My lord, may I allow it to be included because I was indicated by the
And-
department that without mentioning it will not be included in the list. My
Who
lord,
said?
because the main file is with the department. If the requisition does not go, the application itself cannot be listed, my lord. If only it can be included, my lord,
right.
in that event.
It will be included.
May I hand
The
over?
application is নিয়ে নিন তো ডিপার্টমেন্টে চলে গেছে বোধহয়। Call the list.
I appear for the petition.
Yes.
I'm for the statement. I'm for the respondent bank, your lordship.
Well, I am a very humble prayer to your lordship. OTS offer was given at page 64 of your lordship's petition.
64. Yes. 22. 2022.
2022, yes.
Yeah.
Page 64 of your lordship's petition. 1,80,000. Has your lordship got it?
Yes.
Now, my lord, kindly come to my lord page 40 of your lordship's petition. That was a dated, my lord, is very important. 31st of May 2022. 31st May 2022. And page 40 of your lordship's petition, another OTS offer. It goes to 50 lakhs. Yes, 50,000, 5 lakhs, sorry, 5 lakhs. 50,000, 10% represent 50,000. May 2022, 1,80,000. This was up to 2021, 5 lakhs.
Page 40, are you referring to?
Yes,
Page 40 is dated 10th March 2022. You were
yes.
you were supposed to the offer was valid for 30 days and the under the OTS.
On the question, my lord, of 31st of May 2022, that was subsequent to this 40, page 40.
Yes.
It was 5 lakhs in page 40 shown.
No, sir. Figure is how much? 5 lakh. I see 50,000.
Kindly, my lord, it is addressed to me. Last but one.
It's
penultimate paragraph.
50,000. 50,000. Not 5.
50,000 is representing 10% of the OTS amount.
Yes.
Therefore, it comes down to 5 lakhs.
Acceptance of this amount along with 10% subject to the above mentioned such and such.
10% of the total due, my lord, settled by them.
Yes.
My lord, I could not, my lord, know as to what is the total due. My residential house is for mortgage, 50 lakhs is
Why it's there in page 40, 6,70,000.
page 40.
Yes.
Page 40 was a notice, my lord, given as on interest that was calculated due balance 859230 at the cost title.
It was 8,59,230.
Now
Then it was settled at 6,70,000 and you were directed to pay 50,000. 10th of March is
the OTS amount. 10% of the OTS amount. One-time settlement amount. They wanted to settle it at 5 lakhs.
not 5 lakhs, 6,70,000. The figure is
They have
there.
said so. 10% of the OTS amount.
Why are we going into all these things now?
I want to settle the matter, my lord. They are not accounting for the amount.
Obviously, they will not. It was in 22. We are in 25.
No, we are there. But my house is, my lord, has not been taken possession of. They are giving the sale notice without taking possession. I am residing there. My wife is residing, my family is residing there. But my house is mortgaged. But I want to settle it with the bank. 7,83,000 plus 50,000 fixed deposit has been, my lord, credited to the bank. Against a loan of 7,50,000.
Let me hear the bank.
7,83,000 we have paid against 7,50,000.
Let me hear the bank.
Plus 50.
They have already initiated a surface proceeding in 2022 my lord, it is their averment in the petition. My lord, there for years they are taking time, although bank has filed their affidavit in opposition. My lord, kindly sees to these two orders.
Yes, yes.
One is of 16th May 2024 and the other is 16th May, when the 16th May 2025, when they ask for time
Malad, we are paying
on the
this amount.
sales
We are
point, my
mentioning
lord.
before the surface at
Malad.
page 33, amount malad we are depositing. Kindly malad settle
That is different.
No, it is for the bank to settle, not for the court
They
to
have
settle.
mentioned it. This is
It
the
is for
Where?
page 33.
That was long back.
that is long back.
That
That
was
today,
in
my lord.
2022.
Yes.
Plus interest we shall be paying. No,
I do not know.
dispute.
It's for the bank.
No dispute. Malad, we have malad made a prayer malad, at the bank malad take care of it malad and settle the account by giving me the full details of the account.
Where
I
is-
shall settle it.
Where is the provision to go for settlement after the surface proceeding has been initiated and the matter is pending before the
But they
court?
have said the amount is due, I will pay that. They are saying that the
Please.
amount is due, we shall be paying that.
Please, after all this surface proceeding initiated, where is the scope for settlement?
But no, surface proceeding was initiated, my lord.
In 22.
In 2022.
Yes,
And they are saying that in 2022, this amount is due.
right. So after the surface proceeding has been initiated, where is the provision for settlement? Is there any provision?
Not settlement, entire amount I am paying. No question of OTS. It is not an OTS amount. This is the actual due payable to by me.
If anything to be settled, it is in the surface proceeding itself.
But kindly, man, I have made a
How much is the due?
My lord, today, due is 3.55 and with interest. Undue, unapplied
3.55?
interest,
9,55,000.
9,38,000.
No, do not put words in his mouth. Let him say what the figure is. How much is the figure?
3,55,000 is the principal due, and
Yes.
with unapplied interest, other charges
me-
and all that,
give me
9,38,000.
9,38,000.
9,30,000. That has
Let
been
the
proved.
account be settled with me.
No question of settling. This is the bank's
They
figure.
have not given the statement of accounts to me even.
Go before the
Even the
tribunal.
50,000 amount, my lord, that has been slide fixed deposit has not been given credit.
The
50,000 fixed
petitioner
deposit to be
is
credited. That
aggrieved by
statement I
the
am entitled to.
petitioner is
My
aggrieved by the.
representation was made that the bank will take care of it.
Sorry,
I
sir.
have paid for the
Under which provision you show me, I will pass orders. Otherwise, no.
No,
কি বললাম? By the act of the bank in taking steps for recovery of the due amount under the provisions of the Surface Act. Stop. It appears that a securitization application is already pending consideration before the Kolkata Debts Recovery Tribunal number 2 being SA 457/2022. Stop. The petitioner intends to pay off the dues of the bank.
after getting the accounts.
Stop. As the issue is already pending consideration before the learned tribunal, comma, the petitioner is relegated to the learned tribunal for making all necessary prayer before the said forum. The writ petition stands disposed.
So only one direction, my lordship may kindly give, that if such application is made by the tribunal, will expeditiously dispose it off, because my house is, my lord, is there. This is the
It
desire
is-
of your lordship.
It is you who is taking time.
I am
And now it is, the order sheet is here.
now, my lord, the situation is very
Sorry.
My lord,
Next.
the bank is, my lord, raiding my house, my lord, residential house. Well, I shall be settling the amount. Kindly, my lord, give some condition.
No. Yes.
Item number 2 and 3 are analogous, your lordship.
Item number 2,
2 and 3.
2 and 3
Both are against the
respect
same,
of the same property
property.
Same property.
in
are
both the
flat.
matters. In the other matter, who is for the state served? Who is appearing for the state? Did you inquire? GP office?
My lord, here,
So today, just now you serve. How will the other side come? Anyway,
as far as we are
yes.
concerned, my lord, affidavit of service.
All right. What is the matter, please?
My lord, simple, my lord, what I am intending, my lord, just a brief. My lord, this is this apartment owners are there. A society has been formed and which looks after into the welfare as well as the maintenance of the properties. Now, my lord, there was a dispute.
we had referred that dispute to the authorities concerned. Now, my lord, that was made in the month of December. Subsequently, thereto, a show cause was asked from the running committee, the private respondents. Now, my lord, a reply was also given by us. Now, that adjudication is pending before the competent authority who is to adjudicate under section 16. Now, my lord, what has happened before that adjudication is finalized? They have announced an election where we, who have been suspended without any rhyme or reason, now, my lord, a matter is sub judice before the competent authority. Now, if the election is taken, we cannot participate in the election being suspended people. Now, my lord, so if my lord, after going through my brief, whatever I put before your lordship, if my innocuous prayer is that let the competent authority be directed to dispose of this particular dispute within.
But then the process of election must have been started a few weeks back.
My lord,
The
yes.
voters list will come.
No, my lord, that should have ought to have started in the month of May.
Yes.
But they did not. अरे बाबा बोल चीता ना May. एक second. আমাকে আগে
Let
বলে
him
নিতে
make
দাও।
his submission. You have got a different matter.
নাহলে কি হবে
We'll look
না?
into it. Yes.
আপনি আপনার মামলাটা বলবেন আমাকে নিজেরটা
Yes.
করতে দেন। Now, my lord, this ought to have been done in the month of May, according to the bylaws, though they are not mandatory, but as per a judgment of this honorable court only. But it is being done in June because of the reason that before that adjudication and in a slipshod manner and in a haste. If my lord, I have taken out a supplementary affidavit from where my lord will ascertain that when they have declared the election. But be that, I will come to that aspect also. What is the urgency? Now, my lord,
Anybody
kindly take-
representing the board members of the association?
No, my lord, I am the suspended person, my lord.
Respondents 10 to 51.
All are, my lord, all the members of the society. Or we have made everybody, because then order 1 rule 8 will come into play. People will say that everybody is not being put on notice. Election have been declared. So, my lord, as a matter
The
of fact,
association, nobody is representing.
4 and 8, Secretary President, I am representing.
Oh, you are there. All right.
now, my lord, will kindly allow me to place the annexures before your lordship. My lord will kindly see. My lord will
Yes.
if my lord kindly comes, these are the series of allegations which we have annexed. Initially, my lord, at page 25 onwards, my lord will find that from 24/8/2024, I have making
Yes.
allegations against the working. Now, my lord, all these aspects, even defalcation, curtailment of prices, so many allegations. Now, my lord, that culminated all these letters starting from here to from separate points of time, my lord. It has been made till, my lord, till page 32, all these allegations have been made by. Now, my lord, what happens is, all of a sudden, because of this, I am show caused at page 37. Without answering to addressing any of my, and there are other people also, some 3 of them. One is being represented by my learned friend in item number 3, but I am not. Now, my lord will kindly see at page 37, this is the show cause. Now, how they address this show cause to me. You have created a ruckus in the above mentioned date and time during a formal board meeting of the board managers of so-and-so. The entire incident was captured in a CCTV audio video footage and has been recorded in the minutes of the meeting dated so-and-so. You deliberately raised an issue related to unauthorized car parking in the society premises more than 3 months ago, along with Narendra Gupta and Sanjay. Narendra Gupta happens to be the petitioner here. And Mr. Sanjay Jain, and proceeded to disrupt the meeting with threats, filthy abuses, behavior of coastlines. The matter was raised without the permission of the chair, and all 3 of you acted in concert, and the sole apparent aim being to browbeat the office bearers of so-and-so for discharging the duties honestly and faithfully. Even during the meeting, Mr. Rajiv Singh stated that he would continue the parking vehicles wherever he desires within society premises, including common areas, irrespective of association. Now, last but one paragraph, you are immediately called to submit your written response to show cause notice with respect to your conduct within 72 hours of receipt of notice to FM office, failing which your membership or to the board of manager of so-and-so shall be suspended forthwith till such time as you submit an unconditional apology and solemn declaration not to repeat the repeat and support such type of activities in future. Now, my lord, on that day only I reply to it. That is at page 40. Lordship, here I reply to it. That is on 3rd of December 2024. My lord will kindly see. And I ask for the reasons to believe whatever they have alleged. Second paragraph, my lord.
No, it's all right. Do not go through the letter.
Now, my lord, what happens is I make a representation to the concerned authority. After giving them, then what happens? I am suspended. When? If my lord kindly comes to suspension. My lord, show cause, and then my lord will kindly come to 38.
Are you for the state in this matter?
I am for the
What is the steps taken pursuant to the
kindly see the
complaint
annexure
lodged?
5, page 49.
Yes,
We have seek report from the apartment, president of the apartment.
yes.
Then
May I assure my lord's path as to what they have done? It is all here, my lord. If my lord gives me 30 more seconds, my lord. Now, my lord, at page 38 is the notice to suspension. Now, this suspension was done. Now, when this suspension was done, I made a representation to the adjudicating authority. That is on 11th of December 2024. That is at page 43. Suspension made on 7/12/2024, my lord, at page 38. I go to the adjudicating authority at page 43. This was done on December 11, 2024. Subsequently, thereto, I made several reminders because I am lying suspended. Now, my lord, by reminders will start from page 49 onwards. And in the last reminder,
49 is the letter of the authority. 10th of February 25 to the president. Reply.
my lord, I'm just placing one by one, my lord. Now, my lord will kindly come to page 46 first.
What happened thereafter? 10th
Nothing.
of
They
February,
sought for
nothing
a
happened.
reply from them, and and last letter which we gave them, which is very important, page 54, my lord, will kindly see. Here, my lord, I said that they are going to hold elections. Kindly decided.
Yes.
My lord will kindly see.
1st of July.
54, my lord, 1st of July 2025. I said, my lord.
4th July, there is a communication, page 56.
4th July, my lord, they have given me a reply that
Yes.
they have received a so cause which was given to me on 7th of, my lord, if I kindly sees, my lord, at page 56.
Yes.
But this email was received by me, which I have endorsed at page 57 on 7/7/7. And this reply was given to me post my letter, which was received by them on 1/7/2025. Here, my lord, on the last paragraph, my lord allows me to read at page 54. It says, it is needless to mention that till date, no such reply has been received by me from the president, and the time limit was extended to the president and exhausted on 25/2/2025. Now, the month of June 2027/2025, after expiry more than 90 days, no reply has been received. Now, my lord, here, my lord, I have specifically stated, my lord, that we are apprehending that they may go to election. And then what happens in reply to this? They give me a letter of 4/7/2025, where they send me a reply which was sent to them on 2/4/2025 by the my learned senior friend's client. Now, my lord, here the situation is such, my lord, that I am running competent authority is the adjudicating authority. As per the direction, many judgments have been passed, my lord, which is there handy with me, my lord. I will place that they have to do it, and they are within their rights. Now, my lord, I am making several representations. Since I have been, my lord, I have been suspended, I have made that representation. Then, my lord, for 7 months, I have been running from pillar to post. Now, election is going to be held. I have no other choice, my lord, but to come before my lord. So, my lord, what I'm humbly submitting in the light of the judgments of this honorable court, my lord, first time placing, my lord, it's an unreported judgment because I could not lay my hand on the reporting. Shubhodar judgment. Shubhodar judgment. My lord, একদম দেবো দাদা না দিয়ে আমি থাকতে
Yes.
My lord, I'm placing paragraph 2. A short question involved. Paragraph 2, my lord, may I please?
Yes, yes.
A short question involved in the present petition is whether the competent authority under the Act was duty bound to look into the complaints lodged by the petitioner in respect of functioning of the association. Then my lord will flip over the pages and come to paragraph 35. 35 is at page 8.
Yes.
However, the power of competent authority under section 16B inserted by section 7 of the amendment of 1996 is much wider in scope. Subsection 1 thereof provides that if an association or apartment owners having right to exercised by the manager or board of managers fail to perform its function under the act or the bylaws, the competent authority may give it such direction as it considers fit. Subsection 2, now I'm on the next paragraph. Subsection 2 of section 16B provides for the competent authority is of opinion that the function of the manager or board manager is detrimental to the interest of the association or the apartment owners or is against the public interest, the competent authority may give a notice to the manager or board of managers to show cause. If the reply is not satisfactory, the competent authority may go so far as to remove the manager or supersede the board of managers and appoint any member from amongst members of the concerned association or any employee of the state government or any other person as administrator to perform the functions of manager or board of manager. However, for periods such not exceeding 6 months, extendable for further period not exceeding 6 months at a time, the aggregate of which shall not exceed 3 years. Then, my lord, his lordship says it. Now, my lord, if my lord kindly allows him to place paragraph 37. Subsection 1 does not provide whether the powers of CA can be exercised suo moto or require
Hey,
prior.
this is not required because
Now,
we
my
have
lord, will
already
kindly come
made
to
a
paragraph
complaint.
40.
Yes, I've read it.
My lord has read it.
Hmm.
Paragraph 60 is the direction. Now, my lord, another judgment of this honorable court, my lord, passed on 2/3/2023 unreported lordship. Once again, my lord. This is also on the same principle, my lord, that the adjudicating authority may be granted, may be directed to dispose of this particular issue in question. But, my lord, here the situation is slightly different, my lord. Reason is that they are holding an election per se when the dispute is subsisting from December and I am lying suspended. Now, my lord, I have a remedy before the competent authority, but if the election takes place, I am not even allowed to participate or even vote. My lord, heavens will not fall, my lord. Let the competent authority be directed that they may dispose of my representation, which has already there are replies on board. And after that, whatever has been done, whatever.
All right, I've heard you. Yes, what is your submission?
Up to this thing, up to reply, whatever we have got, we had commented to them.
But then thereafter, you had to work, you had to act. In the meantime, elections have been declared.
Not only declared, my lord, I tell your lordship, my lord, sorry for the
When did the
interruption.
notice of election?
My lord,
সাপ্লিমেন্টারি অ্যাফিডেভিট মেলার
supplementary affidavit দিয়েছি sir.
হ্যাঁ আজকে দিচ্ছি দাদা এখনই দিচ্ছি কালকে আমার হাতে এলো
Then my lord, kindly allow me to reconsider. that-
মাইলড ইলেকশন
No, who are you? You are the
Because I am the secretary president, and not only
Right.
that,
who,
the question
what
is, first of all,
authority you have
no,
to reconsider.
question is, my lord, that he is inviting, my learned esteemed senior friend has invited your lordship to adjudicate certain issues by the lead court. Part of it, my lord, are not
The
justified.
court is not adjudicating anything. The
But-
court intends to forward it. It
If
is
the
already
court- if
there.
court says, if
Yes.
honorable court says that he must form a prima facie opinion to cause inquiry and to intervene in the matter, my lord, to that extent, I have no
Right.
say, sir.
In the meantime, the election should be postponed. This is the issue. Otherwise, it
No.
can in regular courts.
My lord, kindly see, that is why if your lordship says election should be postponed, then your lordship must be posted with the correct fact.
Yes.
This urgency that was citing Mr. Trivedi, my learned senior friend, my lord, with his usual fairness. No, position. So he said, my lord, for the 7 months,
Hmm.
so election is not a knee-jerk reaction, my lord, to his complaint.
Hmm.
So for the 7 months, my lord, his client has to wait, number one.
Hmm.
Number two, my lord, that
When was the election declared?
kindly, my lord, on
মাইলড
the-
উইল কাইন্ডলি সে সাপ্লিমেন্টারি অ্যাফিডেভিট annexure P10 25th of June 2025
today, 25th of June.
page 11 light
Now, my lord,
Yes.
kindly allow me.
therefore my 1st July letter therefore
Right,
my
yes.
1st July.
Millard, 31 valid nominations to be received against the vacancy. And Millard, not only that, the 38 page, if your lordship, Millard, kindly takes pain, Millard, with deepest respect to my learned senior friend, Millard, that the suspension, kindly sees the page 38,
38.
during the period, the last penultimate paragraphs, Millard, during the period of suspension, the suspended board members will enjoy all privileges and services due to any owner, but will not participate in the board meeting. My specific instruction, Millard, whether there is a specific, Millard, complaint with the police station or, Millard, to any competent authority after the declaration of the notice, Millard, that whether he was unlawfully prevented, because my case is that there was no attempt on the part of, Millard, the person concerned. That is my instruction. And I can put it on affidavit, Millard,
that my lord, that they have made an attempt. The moment, my lord, they became acquainted with the facts that 31 nomination, because we are declared. It is not a question of notice. We proceeded further.
How many owners are there?
My lord, owners,
We have made them all parties.
all parties. 48, my lord.
48, we have made them all parties.
48. The vacancy is 48. Today, if your lordship is contemplating, or prima facie, my lord, that this election should be postponed, essentially on the issues, matter of suspension, we have not, my lord, discarded him from participating in the election. It was his conscious choice. He was sitting on the fence and waiting, and my lord, observing the shows. And the moment, my lord, where is the case made out by him? And question is, if there is a very good case for him, my lord, to interfere, it's a private dispute. And the inaction on the part of the authority, my lord, is essentially which your lordship says, my lord, I
Yes.
bow down. My lord, that has to be addressed.
It has-
Question is, the authority under section 16, my lord, has, my lord, enjoys ample power, my lord, to set aside election, to dissolve the board,
No, it's all
whatever.
right.
Now, my
Then
lord, where is that averment? Number one. And when I say that during the period of suspension, you will enjoy all privileges and services, how we interpret this? Is it a case that it includes that he was sufficiently prevented from, my lord, participating in the democratic process? Number one. Number two, my lord, all privileges. It was his conscious choice. He maintains
That
angelic
means all
silence.
privileges includes participating in the election.
It was, my lord, because silent,
The
because
board
he,
member,
my lord, debate not only, my lord, board meetings. Now the question is, my lord, this is oxymoron possibly, your lordship can say, but the question is, he is ultimately, my lord, inviting this court to injunct the authority. I have declared the result. I declared the, my lord, the thing. Now, my lord, today, it is too late in the day. Issues has to be justiciable. I assume, not admitting, my lord, that whatever manner that has been adopted or resorted to,
My lord, annexure P10, my lord,
P10.
counting and declaration of election are all on the same day. My lord will kindly see. Filing nomination, now my lord will kindly come to the 1, 2, 3, 4, 5th line. After
are you also intending to contest the election?
my lord,
No.
in my respectful
the
submission,
moment
Let
found
me
it to be uncontested.
let me understand.
uncontested, my lord, I was not being able to participate. I am suspended for last 7 months.
You,
Now, my lord, if any democratic process is, my lord, to be undertaken, everybody should be allowed to participate. Now, my lord, 3 members are lying suspended. 2 have them come before this honorable court. And my lord, just by writing a line, when I asked for us to give me the details as to what is the video footage, what allegations you have made, nothing has been given to me. And within 3 days, I'm suspended. Now, my lord, after suspension, that suspension authority I challenge to the competent authority, just taking the advantage of the dereliction of duty of the
no,
competent.
just try to
Lordship, I
make
apologize.
things short. Do you intend to participate in the election? Do you intended?
My lord, do you
Where is the morsel of proof? And today declaration result we have declared.
my lord, my
That
client
is his
intended, my lord,
perception.
he intended, but since he was lying suspended, he could not file his nomination.
But then he says
Where
the
is the
association
expression of
says
intention?
that
My lord,
says that there was no restraint on you to either to participate or to contest.
Where is such expression in the
One
letter?
minute, one
my
minute.
lord, let me understand.
Moner Gopal
It's
has-
just
My learned
restriction that you have
my learned
created.
senior friend is trying to champion for a cause, and he is wanting to read between lines. He himself forwarded an argument that there is nothing written in the bylaws. One, but what is the normal when nothing is provided in the bylaws? We go by a prudent man's common sense. Now, my lord, a layman who is suspended for the last 7 months, if he goes and files his nomination, he has been caught on the wrong foot. That I've challenged that inaction as well as coupled up with his way of circumventing the entire process and declaring an election and making a fresh committee to come. So, my lord, now he is saying that you were suspended, but you have all the rights under sun. My lord, that cannot be if I'm suspended by a prudent man's common sense, he will challenge that, and therefore he has challenged that particular thing in the before the competent authority. Now, the dereliction of the my lord, to cut the matter short, I don't want to waste any further time of your lordship.
Yes.
30 more seconds by the clock.
The
My lord, let the
election.
procrastinated election heavens will not fall.
The election is on Sunday. You
Lordship.
can vote. You can go and cast your vote. You can cast your vote.
My lord, in my respectful submission,
No.
in my respectful submission, there is a particular adjudication pending.
He will
Yes.
cast
And-
his vote.
One minute,
That
one
is
minute,
that is
one
the
minute.
private
My
decision.
lord
One
will kindly
minute.
appreciate. My lord will
Yes.
kindly appreciate if
Vote হচ্ছে।
my lord, if it is procrastinated, rather it is being kept in abeyance for a certain period of time by my lord's order, if my lord so deems fit and proper, subject to. And in the meantime, if the adjudicating authority comes to a conclusion, then there will be no dispute. Now, my lord, if adjudicating authority tomorrow comes up with a finding in my favor, then the new committee will be there. Then the new committee will be discharged for no fault of theirs. Now, my lord, how it will complicate issues? Whatever has been done by the erstwhile committee. The people against whom allegations have been made are parties to the erstwhile committee. New committee will come into possession. Now they will have to suffer the brunt of the adjudicating authorities, which for the fault which has not been committed by them. So, my lord, why heavens will not fall in my respectful submission? My lord, let
Why
it,
do you want the old committee to continue? You are aggrieved by
I
the
am saying, my
action
lord,
of
administratively appointed.
right. So let
I'll-
the
I'll-
old
I'll-
committee
I'll-
will go away
God.
by the new committee.
My lord,
You
let me take
participate.
let me take it. My lord, wait, just 2 seconds.
নিজের নাক কেটে অপরে যাচ্ছে।
दिया जाएगा इलेक्शन में तो कोई परेशानी नहीं है ना।
बट हमको ये लोग सस्पेंड जो इलीगल
अरे वो तो बात की बात है, अभी आपको वो तो डिसाइड होगा।
अरे
अगर अभी
তোর মক্কেলের অভিমান অন্তরে প্রকাশ ছিল, অন্তরে ছিল, বাইরে আসছিল।
इलेक्शन में you want to participate. My lord, they are saying that the entire process which have been followed by them is not proper. They intended to file their nomination, but they could not due to suspension.
That is
So,
their
my lord,
perception.
Nobody stopped them from
Yes.
putting in their nomination.
Absolutely, my lord.
Had
My
it
lord.
the case that they went to submit their nomination and they were prevented, cause of action would have been arisen
Very
on
good.
that.
My lord, in my respectful
9th of
submission,
July.
in my respectful submission, I am on a higher footing, my lord. If I have made a particular, my lord, within the parameters of law, if I made a complaint, first that complaint needs to be adjudicated.
You
New
have
election cannot.
come so late.
My lord,
Yes.
my lord, I am running from pillar to post from December.
Now today we are in July.
So, my lord, cause of action arose only. My lord will kindly see their election letter. They are saying election will be held on the declaration will be on the 20th.
How does the declaration matter? Thing is 25th of June, notice of election was given. Had you intended to contest the election, you would have gone there to submit your nomination.
1st of July, I called upon the adjudicating authority. As a result of what should I do? Should I come to my lord for at a drop of a hat?
No, it's all right. You
Then, my lord, I come to my lord when I have no other ways,
yes.
which is not efficacious remedy, is the hallmark of writ jurisdiction. Alternative efficacious remedy. Now, efficacious remedy is my lord.
Try to understand. Suppose the authority adjudicates and comes to a finding.
My
Now
lord.
the old committee is outgoing. They will go away. What is the use
My
of the
suspension
adjudication?
remains. My suspension remains.
That
The
is
road-
not for the court.
The new committee can always revoke your suspension.
So what is
No
falling?
difficulty.
My lord, it's there is not only suspension, anything which has been done with a malafide needs to be treated. That is why adjudicating authority is there,
That-
and therefore
that is there. They will consider.
That will be proved by
They will
now you
consider.
now my lord will kindly then what is falling from my lord will allow us to participate in the election. This is what
Right. And the authority will consider your representative. It's not that they will not consider. They will consider.
You will all will participate in this election, and adjudication authority will. I think so. You cannot ask for anything, my lord. Whatever falls from my lord, I can.
Because this can be the best
My lord will
possible
kindly make it
solution.
very clear, my lord,
What
that
is
we
the
will
stand of the
participate in the-
association? The complaint that is there, the authority will consider.
In the complaint, there is no morsel of proof that is
That is for
given.
the authority to
Number
decide
one,
whether
there
there
is-
is anything or not.
Yes, yes, I stop here, my lord.
Yes.
I stop here. But if the election is held in a democratic process, they have every right to take part.
Very well.
And
My
number
lord,
one.
my lord will
And
kindly
but the
direct
question
that.
is, but the question is that
Again,
he
one
will
question.
file a nomination and he will contest.
No, he's not nominating. He putting his nomination. He will put his vote only.
No, my lord. If I want to put my nomination, my lord, I will be debarred.
Nomination, is there time still left?
No,
No, my lord. That is, my lord. If
Today
I
he wants, today, my lord, he wants that he says.
so
this
he
is-
will if
No, no.
once he is championing for the democratic process.
1 minute. The Date of filing the nomination was
My lord,
Why,
supplementary
Mr.
affidavit
Trivedi, my
paragraph-
learned senior friend is Milord in this thing?
I'm much junior to my
না, না,
এটা বলুন
না, না,
না
আরে,
আরে ব্লাইন্ড
বয়-
বলুন
আরে।
না আমার আমার ভালো লাগে না দাদা, তোমার মুখে আসলে আমার ভালো লাগে
এরকম
আপনি-
করিস না।
না দাদা
আমাকে একটু সম্মান দিতে দে।
না আমি পারবো না।
last date for filing the nomination was 9th July. And then withdrawal of nomination was 11th. Scrutiny was 13th.
My lord,
Today is
The election is
my lord,
held.
my lord,
If
my
the
lord,
election
allow-
is held,
if my lord passes an order, my lord, we can do it today, my lord. We are today on Friday.
you accept the nomination. Where is the difficulty?
no, no, kindly do not do
No,
this.
no, that now
Kindly,
cat
Milord,
is out
I
of
know.
the bag.
Then means
Now cat is
no,
out
no,
of
no,
the
no, no, not what. Milord, then Milord, it is a really Milord good art of advocacy, because when I see you cannot participate in the any board meetings, that means if he is elected, he has to participate. That means suspension goes. He is asking Milord the read code to interfere with suspension. That is the art of advocacy. And Milord, the elegance of cerebral electricity.
Listen.
No,
The
either your lordship says that the read code can interfere with these issues which are not justiciable, number one.
the court is not entering into
No, if the court does not enter, then court cannot possibly, subject to correction, since your lordship indulgence, Milord, free speech all the times, Milord, from the bar. Milord, I draw, Milord, inspiration from this encouragement. Kindly take Spain once again, Milord, and Milord, read between the lines. You are not entitled, means Milord, suspension is there. And
Last 6 months, no board meeting was held.
no,
No board meeting. Let them come up with a board meeting.
You are in a way asking the court. to-
please come.
I am
The-
not.
Record
My lord
my
will.
submission that
My
I am
lord will.
using this prayer for.
My lord
Honor.
will allow me to participate. my
Lord, I strongly oppose this.
lord. What you cannot.
Milord, kindly,
What you-
kindly, Milord,
Give me the book once.
My lord.
competent authority can very well, Milord, interfere with the suspension. 16(2)(b).
হ্যাঁ আমি তো বলছি দাদা সেইটা
তোরটা বল, তোর বক্তব্যটা বল।
আর কিছু না দাদা।
হ্যাঁ? তো তো উল্টো।
দাদা ও আর কিছু বলবে না তুমি আমাকে এত
192টা ফ্ল্যাট কি ঝগড়াঝাটি হয়? কে তোকে দেয়নি? না।
তোমার তো তোমার my lord কে বলবো ডিসাইডিং অ্যানালগাসলি
এই শোন না,
তুমি কিছু বলবে
এই তোরটা
I have some small submissions.
Yes.
But item number 3, those analogous. My submission is, my lord, I am not a suspended member.
All right.
I was the ex-president.
Item number 3, I have not discharged. I do not have.
Not been.
No, we have served, my lord. We have served. I have served,
I
man.
require to, I require the copy, Milord.
I am sending the copy.
Kindly take
I will serve the.
You also listen what he says so that it will be easy for you. He'll serve a copy. What is your prayer?
My lord, I have been restrained from taking part in the election. I wanted to make now nominations, my lord. If your lordship,
Who restrained you and why were you restrained?
my lord, I was not given the NOC. The NOC is required.
No,
If your
no
lordship
objection
kindly
certificate.
comes to page
You
number
did not
35.
pay your
Yes.
charge.
Yes, my lord.
Then what is the reason for not issuing
This
the
is the question, my lord, for which I went before the competent authority. The competent authority is sitting idle.
আবার ইলেকশনে
I am before your lordship.
তোমার মক্কেল দেয়নি
Mhm.
Their modus operandi is no one except their selected persons will be in the board. This is the only modus operandi that they have.
And common submission.
My lord,
Yes.
they are not allowing anybody
Yes,
to participate in the
Harding
election.
If your lordship kindly comes to page number 35.
Competent authority is well within its power, Milord, to interfere and to force.
Yes, yes, that is all right.
In absence of opinion, he is asking the High Court to pass an interim order on a non-justiciable issue.
Very non-justifiable issue.
Absolutely private.
My power has
Different
been,
case, High Court did not even Supreme Court follow.
my lord, Article 226. I have learned it from my learned seniors.
My lord, may I submit?
I am my,
Yes.
I will take only a couple of minutes, my lord.
How many petitioners are there in your case? One.
I'm one, I'm the
You are
ex-president.
the ex-president.
Ex-president. My lord, if your lordship kindly comes to page 35 of my writ petition, my
The
lord.
allegation, Milord,
I will come, I will come. I will-
Copy, give a copy to him.
দাদা এখনই পড়ে করে দিতে পারবে
একটু মক্কেলের সাথে কথা বলে নিই, কেন করেছে?
আরে এখন
Give a copy.
এখানে শেয়ার করুন
Milord, if your lordship is
In that
saying-
case, take it at, I'll take it at 2 o'clock. You take instruction. Do you follow this order? This matter also order will be passed.
Item 3 also, দুটোই।
Duro.
Because two different orders in the same complex where election is being held on Sunday. If two different orders are passed, then it will be a problem. So a common order has to be passed that will apply in both the matters.
A copy to be served to me.
Yes, yes, let a copy,
I'm serving it, my lord.
please serve. Did you serve the GP's office?
Lordship, it has already been served now.
Check who's there.
সোমবার নেই, সোমবার নেই না।
No, no, Sumba.
Yes, I pick it up on Monday. You postpone the election.
Yes, my lord.
Yes.
Monday from 11 o'clock.
No, my lord, kindly.
My lord, please. From Monday.
That will be better.
No, Dada.
এই সুযোগ নিতে দেবো।
Which issue I will take instruction, which
What was the competent authority doing for so many days after receiving the complaint, and Sunday is the election?
There are several complaints against them.
The court is the court intends to postpone the election. I make my mind clear. The competent authority has to act immediately so that the issues can be resolved. Right? But you take instruction, and I'll give Mr. Basu to go through the brief, at least what is the objection, what is the allegation.
আমি না দাদা, আমি তো দিয়ে দিয়েছি কালকেই সব।
Call the next
I'm
matter.
grateful.
2 p.m. my lord, 2 p.m.
Yes.
on a light, the previous matter, there should have been a determination as to who is senior to who. The number of times we
My lord,
heard,
I am for the respondent, my lord.
he's calling,
The court is tight-lipped.
but this, I had mentioned for extension of interim order.
Yes.
By consent of the parties, he is here. If it can be extended and kept any day for hearing, I'll tell you, Lordship, this
But
was.
I am objecting because, my lord, I have made, my lord, instruction. Necessary sir, for the respondent, my lord, your lordship, kindly, if you please to direct me to file, my lord, evidence in opposition in short date, that would be better, my lord. Subject to.
But then he can, the Lordship can keep the.
In that case, the interim order is being extended.
Yes, my lord, short time, my lord, very short time. 2 weeks, my lord.
When will you file your opposition? In 2 weeks?
2 weeks, my lord.
Union of India will file opposition within 2 weeks, and it will come from the Western Railway, and I believe it.
3 weeks, my lord. Then
Uh,
3
uh,
weeks.
Have I joined this building for the first time today? Learned advocate representing the respondents seeks time to file affidavit in opposition. Stop. Let affidavit in opposition be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing immediately on completion of affidavits before any other bench having determination. Stop. The interim order that is subsisting is extended till 26th September 2025 or until further order, whichever is ordered.
Lord, may I please make one and pray for one indulgence? May would you Lordship please to make this interim order to dispose of the application?
No, sorry.
26th
Sorry,
of.
my lord, one indulgence maybe, my lord, record, my lord, your lordship. Kindly, my lord, note it down that if any, my lord, further, my lord, any proceeding is there, my lord, that can be subject to, my lord, result of the writ application. Otherwise, my lord, it's a public, my lord, public function, my lord. The rail, my lord, cannot stop the project, my lord. That is the problem, my lord, which I face, my lord. If, my lord, petitioner is ready to, my lord, serve the all the materials, my lord, we have no objection because
Yes,
time
yes,
is there,
let
my
him
lord.
say by way of an affidavit, that's what I want.
Yes, my lord.
Let him
That
say.
will be better,
that
my
one.
lord.
That is my writ petition that I want to serve.
Yes, my lord. You will kindly note it down, my lord.
What? Yes, my lord. The petitioner wants that you will permit him to serve
Oh,
the railways.
Yes, my lord. I have no problem, my lord.
Bring written instruction.
Yes, my lord.
Call the next matter.
My lord, I am for the petition.
My lord, I am appearing on behalf of the opposite party number 5 and 6.
Respondent number 5 and 6. Not opposite party.
My lord, this is the matter, my lord, was pleased to hear on Monday, my lord.
Yes.
This is with regard to election and thereafter a counter election being declared, which is fixed on, my lord, Sunday. And my lord, this was with regard to the postal department, a union of the postal department. Now, my lord, a substantial hearing has already taken place. Union was supposed to bring written instruction. Now, if I may just do a quick recap, my lord, a division of this particular union, which is roughly equivalent to a district,
there was a divisional conference. In the divisional conference, an election of the committee took place, and it was under the supervision of a departmental observer. That is an observer appointed by the Department of Post itself. Committee was elected, and thereafter, the department has not granted the approval to this committee as of yet, my lord. This is where it stood when a counter conference was declared by another faction, my lord. The same conference was declared once again, and it is supposed to be held on the 20th, my lord. That is on Sunday. Now, my lord, my prayer is for approval of the committee that has been elected in the election that has already been conducted, and a stay on this particular counter conference and election that has been declared. My lord, in the meantime, I would produce one thing, my lord. The report of the observer, we have obtained a certified copy of the same. I would seek to produce it, my lord. The observer's report.
Who was the observer?
My lord, observer was Inspector of Posts, Boshirhat 1st Subdivision, and he was appointed by a formal order of the Superintendent of Post Offices of that particular division. And the appointment order is also annexed to my writ petition.
Which portion do you want me to read?
My lord, the very last in the next page, my lord. Just after the table ends.
All observed
That is the
procedures
main part
are
of the
found to be in
that
compliance.
vindicates the conference that has taken place.
Right. The overall conduct was peaceful, smooth, and adhered to by the established norms. Right.
So now, my lord, with that being said, if I may refer to my formal prayer for approval of our committee, that is on page 53 and 54 of our petition, my lord, the writ petition. (52) is also relevant, my lord, because this was the committee elected on that particular day, signed by the observer himself at the bottom. And 53 and 54 is the formal prayer that we have made to the SP.
Which has not been acted upon. This has not been acted upon.
This has not been acted upon. And the counter conference has been declared.
Counter conference has been declared. Yes.
I am for the private respondent.
All right. Yes.
I have received the order on 8 July
25. So, my lord, we will pass the order after observing the observer reports, my lord. So, my lord,
There is a request at page 53.
Yes, my lord. 53.
For approval of the election that has been.
Yes, it is admitted fact, my lord.
This is an admitted fact.
Fact.
You have not
So-
acted.
So, my lord, only my lord, my prayer is, my lord, I will pass the order in terms of the observer
Report. Yes.
So, but in the meantime, we'll have short stay of the
Stay of what?
election.
Stay of election.
Election.
Which
Very
has
short
been
period, yes.
declared.
Page 55. Well, no such election was held according to page 53. Kindly come. We are for the circle. Circle means, my lord, state. Here, this organization, circle means state. And division means, my lord, district. Well, no election was held. Prior to that,
There is a report of the observer that is before the court.
that observer, my lord, observer of our organization, circle secretary is the main person, my lord, circle secretary in our organization. Lordship, kindly have a look into, Lordship, kindly. My lordship, kindly kindly have a look into the constitution.
Please wait.
And the kindly one copy of the report of the observer, my lord. I am the secretary of the circle. So, my lord, I will pass the. I am the secretary of the. Pass the order, my lord, in terms of
The
the Bengal, my lord.
petitioners claim to be
Report.
bona fide members of Bharatiya Postal Employees Association, Group C, from Barasat branch. An election was conducted by the Employees Association under the supervision of the observer. Stop. A committee was constituted and it was forwarded to the Superintendent of Post Offices, Barasat, on 30th June 2025. Stop. The same is awaiting approval. Stop. In the meantime, another unit of the association has declared election, which is scheduled on Sunday, 20th July.
This is approved by Central Committee, my lord. That letter with me, my lord.
2025. Which one is the election date?
Sunday.
Page 55.
55. Yes, my lord. Page 55.
Look at the date. I do not think it is the proper date.
My lord, kindly come to page 55.
Page 55, second line. It will be held on the day that is mentioned over there.
20th July
26.
that is 2025, my lord.
I do not know. It is mentioned 20th July 2026, the election will be held. The court is not saying anything. It is beyond notice.
Lordship, kindly have a look into other document from the Central Committee that was approved election, my lord.
My lord, kindly looks into
Kindly-
memo date also.
And
2020.
that vote, my lord, only total voter
Hastily done, my lord.
172 total voter, and presence of voter only 68.
Next. The report of the observer dated 4th July 2025. Has also been placed before this court. Stop. Paragraph. The petitioner prays for a direction upon the Superintendent of Post Offices to approve the list of office bearers
Kindly direct the response number 2, my lord.
who were elected on the election which was conducted on 29th of June 2025. Stop. Next. Learned advocate representing the private respondent submits that no election was conducted on 29th June 2025. Stop.
And and state committee already communicated a letter to stop the election.
The state committee communicated a letter to the Superintendent of Posts to stop the election.
And also the petitioner.
Stop. Next. From a notice which allegedly is in support of the election to be held by the private respondents is annexed at page 55 of the writ petition. Stop. The notice is dated 25th of June 2024 and it is signed by the Secretary of the Employees Association on 25th of June 2025, and the notice mentioned that the election is scheduled to be held on 27th July 2026. Stop. Paragraph. On a perusal of the said notice, it appears that the dates are absolutely incorrect. Stop. A proper election ought not to be held relying on a notice which has so many errors. Stop. Next. In view of the above, the instant writ petition is disposed of
Response number
by
2,
directing the
response number 2, my lord.
yes, Union of India, who will be the authority? The chief postmaster or the superintendent of posts?
Because it's a division.
Response number 4 is directed to take a decision on the communication made on 30th June 2025, taking into consideration the report of the observer, independent observer, and inspector of posts, Boshirat, 1st Division, dated 4th July 2025. Decision bolen to in accordance with law at the earliest but positively within a fortnight from the date of communication of this order.
After giving opportunity to the private respondent also, my lord.
What opportunity? It has been forwarded result of the election. Where is the
Whether
opportunity?
that election is valid or not.
That the observer is there.
Of the, my lord, I am the secretary of the state, my lord.
I do not know state, district, or country.
My lord,
Next.
Lordship, after giving opportunity, otherwise, my lord, the report.
The fate of the consideration shall be made known to all concerned. Writ petition disposed.
Well, an express stay upon the election, my lord.
I have mentioned that
It
cannot take place relying on a notice which is so erroneous. At least 3 in front.
I'm grateful. So hastily put together. Now, my lord, the next petition, my lord.
Yes.
Is the actual
6, item number 6.
6.
6 is different, my lord.
6.
5 and 6.
6.
6 is something different, my lord.
6
is regarding the election of state.
Now, my
In
lord,
the month of April.
You are for the union.
Confirm.
We are appealing for the Union of India.
may I just place my case, my lord. My lord, in the previous matter, it was a divisional conference, divisional election, and it was held under the aegis and supervision of the departmental observer. This one relates to the conference and election at the circle or state level. It was conducted on the 12th, supposed to be conducted on the 12th and 13th of April this year. Now, my lord, the main difference is the divisional conference and election is held under supervision of an observer. In the state level, a higher level, no observer was invited, no observer was appointed. What happened was, my lord, taking advantage of this particular scenario, the private respondents in this matter, especially private respondent number 6, he and his men and agents created a situation where those divisions which were not aligned to them, they were not even allowed to enter the conference venue. I would just, my lord, make out a case that such malpractices has taken place, a prima facie case, praying for a direction upon the Postmaster General to initiate an inquiry. And if it is found that such malpractices has actually taken place, to withdraw the approval that he has already given in this case. Now, my lord, immediately after the conference,
Where is your complaint?
My lord, page 48 onwards, my lord. There are 2 representations here.
48.
Page 48, my lord.
And divisional secretaries are making this complaint, my lord. And the 2 petitioners here, both are divisional secretaries. My lord, the relevant part of the complaint would be on page 49, my lord.
Very well. Has any steps been taken?
No, already approved. Our election,
Yes.
our already approved, my lord. In the month of April.
These representations, my lord, are in surplus now.
On our part, in respect
No,
of
my lord,
My submission is that they had made a representation, that is still. But this page 40, there is copy. But my submission is that, my lord, these representations have been made and that has been submitted to the directorate for guidance of further action, my lord. In the meantime, a body was directed to be published, and as because there is no official obstruction or advisory from either from the police or from directorate not to publish the list of the members, that list has been published.
No, that he admits that the list has been
40
published.
approved, my lord.
But then did you take into consideration page 48 and 49?
No, my lord, because, my lord, this later they made the correspondence, the complaint, and that complaint has been forwarded to the directorate for further guidance, as because no instruction from that has come up till date. So no steps could be taken by the respondent, the Chief Postmaster General, my lord.
The Postmaster General already approved.
No, that is
In the
defined, my
month of
lord.
April,
As per the
Now, my
as
lord,
per the
kindly
complaint that
take
is
it into
made by
consideration, my lord.
as per the complaint that has been made by the petitioner, that complaint has been forwarded to the directorate for further
Why
guidance.
the Postmaster General doesn't have any authority to consider it?
Because, my lord,
He should ideally have, my lord.
because, my lord,
there are no such untoward incident, nothing.
You are the, against you, the allegation is there.
We have also made an allegation against him.
My-
Regarding
my lord,
election of divisional
when it is a
election
dispute
at
between the-
Bongan and Bosirat, same happened, my lord. Already
My
approved
lord,
page
may I
40, my lord.
may
Kindly
I
have a
just
look into
make
page
out my
40.
case, my lord.
my lord, my submission.
Okay, your case I have followed.
Two parties, my
There
two
has been-
union, my lord.
Two?
Two union, my lord.
Yes,
Because
I can understand. There is a fight
Now-
between the unions.
Not two union, one
But then,
union,
my
two
lord,
group.
my lord, then two,
One
my lord.
union, two group.
But as because the representation was made and that has been addressed to the higher authority for directorate for consideration, so that has been kept till date, my lord. That was not taken in consideration by
You cannot sit tight only because by forwarding it to the higher
And-
authority.
and in the meantime, that
My lord,
has
I
been
may
solved,
ask
my lord.
myself this question, my lord.
No untoward report. For that reason, my lord, already approved
why-
page
My
40.
lord, I may ask myself this question. If the PMG has forwarded it for consideration of the higher authority,
But
how
their
can he
allegation
approve,
is,
my
my
lord?
lord, but their allegation
cannot-
is some
he cannot
FIRs
give
were
the
done,
approval.
some other things are there, but that was not circulated to us through proper channel, my lord. So we are not aware of that thing, my lord. Only the representation has
No, no.
been made, that has been
If
forwarded.
a representation is made, if you consider, you are the chief postmaster general, you are not a post office, simply forward it. You should have some powers to deal it.
Yes, my
My lord,
lord.
may I just, my lord, may I make that submission?
Into
My
our
lord,
constitution.
my lord, kindly one
Constitution
thing,
of
The objection lodged by the petitioner before the chief postmaster general in respect of an election proceeding is pending consideration since April 2025. Stop. In the meantime, the result of the election has been declared and a new body has taken charge. Stop. Paragraph. Learned advocate representing the Union of India submits that the chief postmaster general forwarded the complaint to the higher authority. Stop. As there was no further communication from the higher authority, comma, the postmaster general, chief postmaster general হবে, did not take any steps in the matter.
No, my lord, he has approved the committee.
Because, my lord,
He has
approved
approved.
only on the
Achha,
ground. There is no
He's
official
already
instruction, my lord.
Note and thereafter approved.
Chief
My
postmaster
lord,
general.
because no obstruction, official obstruction not to form the committee, my lord.
No
Not
such
to approve,
obstruction.
no obstruction to approve the panel. For that reason, he has approved it. Kindly note my submission.
Did not take any further steps to inquire into the complaint lodged.
That is also
Stop.
my lord.
The postmaster general proceeded to approve the members, elected members, as there was no restraint order from any competent forum. Paragraph. Next. Learned advocate representing the private respondent submits that as the election was conducted in the proper manner, comma, the postmaster general proceeded to approve the election, the result of the election.
Office behalf.
Paragraph. Next. Upon hearing the submission made on behalf of all the parties, it appears that despite receipt of an objection
Madam, may I make my one
from
submission?
the
There is also a meeting called for by the respondent authorities on 4th June 2025. They were pay annexure P7, my lord. They have stated, my lord,
yes, then
that for a meeting to be conducted, considering the inquiry proceeding, whether anything has happened or not.
yes,
It is not with that
But-
regard, my
Yes,
lord.
my lord, inquiry
But
proceeding
he
is
said
pending.
My
after
lord,
that
then
was
my
been
lord
done
kindly
also,
allows
that
me to
meeting
make
was
my
also,
fullest submission.
but that notification also there, my lord. That
Yes.
step he has taken, but as because, my lord, no further, as because as for my lordship, my lord,
Hold on.
that he had taken that step only to convene a meeting. Page 57, my lord.
There are other facts, my lord. You want to file my opposition, my lord.
Despite receipt of an objection, challenging the process of election, comma, the authority did not take steps to respond to the same. Stop. The authority ought to have proceeded to dispose of the representation and should not have kept it pending for no specified reason. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the Chief Postmaster General to consider and dispose of the objection filed by the petitioner strictly in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. If the allegations made in the complaint filed by the petitioner appears to be proper, comma, the necessary remedial steps shall be taken.
After giving opportunity
till
to
such
the
time, my lord.
present office bearer, my lord, 5 days after giving opportunity to the present office bearer.
I don't mind that, my lord. But my lord,
It
till
has
then,
been mentioned. It has been mentioned in accordance with law.
After giving opportunity, my lord, otherwise.
If required, opportunity of hearing may be provided to all the necessary parties prior to passing a final order in the matter. Yes, please.
my lord, till then, my lord, this approval may be kept in abeyance.
No, my lord.
It has already been
No, my lord.
approved. It cannot be done.
After
Next.
4 months, they
At
have
least-
come.
My lord, approval was given on the second, my lord, 2nd of July.
I have
come on the
directed that
third,
in
my lord.
case they come to a conclusion that there is some error, then remedial steps.
At least, my lord, kindly protects the petitioners at least.
What type of protection?
Because what they are doing, my lord, they are simply firing us from the union, my lord. At least we
Let
may
the authority take a decision.
my lord, kindly we may be protected, my lord. No coercive action by
Protection,
the union against us, my lord.
No, that cannot be done. Yes.
My lord, I am for the petitioner, my lord. Yeah, my lord.
I am for the respondent number 3 and 4.
Lord, here, my lord, my son suffers from the autistic child, my lord. Now, my lord, respond number 3 is the school where he studies. Respond number 4 is the principal. Now, my lord, I am also in the committee member of the, my lord, the school now, governing body.
Tell me one thing. Why is this education matter over
It's not
here?
education matter, my lord. It is under, my lord, it's group 9, my lord. It is with regard to, my lord, the rights of a person with disabilities act, my lord. Because yes, my lord. Now, my lord, he's an autistic child, my lord. Now, my lord, he studies in a respond number 3 school. Now, my lord, there's a concept called shadow teacher. There was always a shadow teacher with him when he was studying. Now, my lord, I have some difficulties with the respond number 4 for personal reasons because I'm also the governing body. Now, the respond number 4 is not allowing the shadow teacher to accompany my son in the school, and I've driven her out from the school, my lord.
All right.
Lord, here, my lord, I'm seeking, my lord. My examinations are there on the corner, my lord. My pretest and, my lord, class 10.
Show me the book once.
My lord, section 2.
Where there is
I'm showing my lord.
provision for the shadow teacher.
Yes, my lord. Kindly, my lord, takes, my lord.
You have the book?
My lord, I've got the tab. My lord.
Give the section so that it can be put up on the screen.
Yes, my lord.
What is your instruction?
Yes, my lord. There are two types of allegation has been given by the petitioner. Number one is financial allegation, which has been which is
What about
investigating.
the shadow teacher to be allowed with the student who is?
We have two psychologists appointed, and they are giving their service properly, and we have proper qualified teachers, obviously. And the next thing is that if I allow the shadow teacher to this particular student, then I have to allow the shadow teacher for the other students also, because there are so many PWD students are studying over there. So if everyone will come and apply for the shadow teacher,
Where is
then
the provision of
Yes, my lord, it
a
is there,
shadow
section
teacher?
16
Section
is there.
16.
And my lord, only the difficulty is that he already had a shadow teacher. The teacher was always there with him from 2003, my lord, when he was enrolled in the school. From that post to 2011, my lord, from that time shadow teacher was there. Now all of a sudden, my lord, when I made complaints, serious complaints against the management, my lord, then only he was not allowed to, the shadow teacher was not allowed to enter.
What is exactly the role of the shadow
My lord,
teacher?
may I, my lord, here, my lord, it is, my lord, the judgment.
Right.
My lord, the shadow teacher helps the student.
16, section
16, my lord,
16.
kindly, my lord, takes subsection 4.
Subsection 4, provide necessary support individualized or otherwise in environments that maximize academic and social development consistent with the goals of full inclusion.
And my lord,
Right.
kindly will takes thereafter section 2 S1 and section 2D, the
All right.
caretaker, the caregiver.
No, is it necessary that the caregiver has to stay with the child always when he's in the school also?
Well, may I read out the definition of caregiver, my lord, once, my lord. Section 2D means
2D.
a person including parent and other family members who, with or without payment, provides care, support, or assistance to a person with disabilities. My lord, this person is autistic, 70% autistic is there, my lord. He is, my lord, moderate autistic person. Now, my lord, for various acts of his, my lord, in paragraph 3, I have stated, my lord, why it is difficult, why it is required, my lord. Can you take paragraph 3 of my writ petition, my lord?
My lord, no disability certificate.
Yes, it is there.
Is a neurodevelopment condition.
Yes, my lord. The difficulties with sometimes he has difficulty if someone is not there, my lord. He might get frightened and thereafter, my lord, because now, my lord, kindly, my lord, takes the.
Are you the only parent of a child who has a shadow teacher in the school, or are there other children with shadow teachers?
My lord,
No, my
I
lord.
always.
No, my lord.
Wait.
My lord, I don't know about the fact because I have not asked my client. I have to ask, my lord. But my lord, I always had a shadow teacher. The reason is that from 2000, can you take page 17 once? The reason the government, I'm not saying it, this is the government certificates. The reason is stated, my lord. Kindly, my lord, takes page 17. This is the Apollo Hospital. Thereafter, the West Bengal government's welfare. Kindly takes page 17 once, my lord.
This is not the disability certificate.
Wait, sir. Let us see what it is. Page
17.
17. Yes.
Kindly, my lord, takes the chief complaint diagnosis, my lord.
Autism spectrum disorder.
Yes, my lord.
ASD. Right, then.
Class 9 state board difficulty in speech communication. This is the reason why. And my lord, the habit of nail biting. That's a neuro disorder, my lord. That is the reason, my lord, if someone speaks with him or my lord, communicates with him, he gets scared. And if he cannot communicate, the shadow teacher, my lord, helps him, my lord, to pacify or my lord, to calm him down. And my lord, kindly, my lord, takes the medicines issued, and also, my lord, they say that the diagnostic and page 18, kindly, my lord, takes them thereafter, my lord. It is a certificate by the West Bengal government, my lord. On the handwriting part, my lord.
Page?
18, next page, my lord.
Yes.
The handwritten part, my lord.
At present, ISA administered.
Moderate.
Now, this is a moderate autistic, my lord.
Clinical examination.
All right.
And my lord, kindly take the clinical examination. Affected part, brain.
Autism spectrum disorder chief complaint of
The next part, my page 18. Chief complaint, and thereafter, my lord, they are finding, my lord.
Yes, affected part is the brain.
Impairment in social communication.
My lord, kindly sees impairment in social communication.
Is the school meant for autistic children?
Yes,
No.
And it is an inclusive
This is the
school.
inclusive.
It's an inclusive.
Yes, it is. And my lord, in the website it is there also. Now, my lord, even my lord, the act also, my lord, there are provisions, my lord, which the school is required to take under the Education Act. My lord, they have to give an education. Now, my lord, with regard to this teacher, my lord, even I provide for the salary of this teacher. It is not the school who provides.
He is your personal caregiver.
Yes, my lord, I have to
provide.
My lord, the act also says that the school required to provide, but I don't require. I am giving it, my lord.
No, if the school had a caregiver, then the caregiver would have been meant for all.
All
But this is your personal one.
personal, which is
Right.
allowed by the act, and it's allowed because of disability and is a moderate autism. Therefore, he's allowed. And it is not that this first time he's being allowed. He has been allowed since the time he has entered school. Since that point of time, my lord, he was there. He had a teacher. Now, my lord, now, because the reason is that I have raised some serious disputes with regard to the conduct of the board of the, if I show just one letter, which I issued, my lord, kindly, my lord, takes page 76, 72, my lord, I'll take, my lord, once, my lord.
Why have you not implemented anybody from the state? Is the state's
My lord, I have.
the service?
I have, my lord. I have. Well, 1 and 2 is there, my lord.
1 and 2, did you serve?
I've served, my lord. Yes, my lord, I've served.
No, no, the state, the Board of Secondary Education.
Served, my lord.
এখনো দেখাচ্ছে না আপডেট, but I've served by email also.
I've served by electronic mail, my lord.
With leave of my learned senior, my lord, it has been served by speed post as well as email. The tracking information is not yet updated on the website, but I have served by email also, my lord. May I hand up additionally?
Well, page 72 is one of the letters which I've addressed. And the allegations have been made, specific allegations has been made against the principal. After, my lord, I've made these allegations, my lord, my son has been stopped from entering the school, or rather the shadow teacher has been stopped from entering the school. That is the reason to harass me. Well, the allegations are very severe in nature.
Yes.
My lord, may
Just, I don't want to, my lord, right this moment, my lord. The future of my child, my lord, is important. The reason is that he'll be doing his boards now.
Yes.
Well, for the boards, he'll be sitting for the first time, and practical examinations are from 22nd. But if he cannot,
2nd of
July, my lord. 18th June, 18th July, June, he was not allowed to enter, my lord. We are in the first opportunity. We are here, my lord.
18 June was 1 month back.
My lord, we had served thereafter, my lord. Police complaints are there, my lord. Kindly, my lord, takes the letters. We have issued letters to them, page 67 onwards. Kindly, my lord.
All right, let me hear. Yes.
My lord, he is not coming from 1st June. From 1st June, he is not at all coming. On 18th June, whether he has come or not, we don't know.
Why
But
you don't?
it is absent. But
It's
it is
absent.
marked as absent.
That means he didn't come.
He didn't come.
All right.
Kindly.
No, no, it's all right then.
And our teachers are very much specified. Sorry.
No, all on a sudden, why did you stop?
All on a sudden, we stopped only because of that. If I allow this shadow teacher to this particular student, then other parents are coming to us and telling that I have
Is
to
it
give.
for the first time that a request has come to you?
This is the first time.
First time?
This is the first
This
time.
child is having the shadow teacher since when he joined school?
2011.
He is
2011.
now he is in class 10 and he'll be appearing for the board examination, and
Exactly.
he's an outgoing student. Why don't
Yes.
you permit the child for only few months? Hardly a few months are
Everyone,
left.
actually, every parents are coming to us and they are demanding it.
I have inquired. You can take a decision whether a shadow teacher is required or not. This child is having this benefit since he joined school. And just prior to his appearing for the board examination, you will not permit the shadow teacher. That is going to create an adverse impact on the child.
The matter is that, my lord.
Actually, matter is something else.
No, my lord.
What is the matter?
Matter is the petitioner is demanding some illegal favor. That is, as his son is the autistic child, he cannot write. He needs the writer.
Right.
So the writer must be above aged or 11 class 11, 12 pass out, something like this, so that he can score the good result. That was the illegal demand, which is beyond the law. That was the illegal demand. And that's why that's type of allegation
There
and
must
that's type
be
of
a proper system as to how the shadow teacher acts.
yes.
It is not that somebody, meritorious student sitting on on behalf of that autistic child writes something. It is not that. There are rules in place how to take care of these children.
And my teachers are also creating some objections because
Yes.
they are RCI certified teachers. They are also
Yes.
creating some objections that raising some objections actually that how she is handling this handling procedure was not up to the mark.
Maybe.
And we don't know about the qualifications of the shadow
Exactly.
teacher.
Maybe
So it may be
it may be proper, but this shadow teacher was there for so long since the child got admission in the school. He is just outgoing, be here for a few more months, let him go out, then you put your own regulations in place. All right.
But the main thing is that the shadow teacher personally don't wants to come to the school.
That is a different thing. It is for the child's parents to take care of a
Opinion
shadow
of the
teacher.
shadow teacher should we take. The opinion of the shadow teacher, the personally, the shadow
He's
teacher
approached
don't
by a
want
shadow
to
teacher
come.
now. He's saying
Personally,
that he has
the don't.
approached-
Personally, she don't.
Please come.
How does he know that?
Please come, Pradeep. The petitioner is the father of a minor boy, aged about 17 years,
17 years.
suffering from mild
Autism spectrum.
autism spectrum disorder. Page 3. ঠিক আছে? দরজাটা বন্ধ করুন। The child is suffering from neurodevelopment problems. Stuff. He is studying in this school.
11. From 2011, my lord.
In the respondent number 3 school.
Respondent number 3.
Since 2011. Stop. From the admission of the child in the school, he was allowed to be assisted by a shadow teacher. Stop. Paragraph. The petitioner alleges that only after certain complaints were made by the petitioner against the principal of the school, comma, the principal is disallowing the shadow teacher to accompany his son. Stop. The son is the son of the petitioner will appear for the board examination next year.
Yes, the examinations, practicals are starting now.
Yes. Next year, the board examination.
Yes.
Yes.
Next year board examination.
The practical examination for the board examination is due to commence from 22nd July 2025. Stop. The son of the petitioner cannot perform and becomes uncomfortable in the absence of the shadow teacher. Stop. For the interest of the child, comma, the petitioner prays that the shadow teacher be permitted to assist the child till he appears for his board examination. Until he appears for and completes his board examination. ঠিক আছে? Learned advocate representing the school submits that admits that the son of the petitioner was permitted the assistance of the shadow teacher since the day he joined school. Stuff. It has been submitted that the shadow teacher has currently not been permitted because there are similar requests from parents of other similarly placed children studying in the school. Stop. As there are several trained teachers in the school, comma, the requirement of a shadow teacher to assist the child of the petitioner may not be required, will not be necessary.
My lord, RCI certified teachers.
আচ্ছা যেখানে বললাম না টিচার্স আছে RCI trained RCI certified.
বলেছে 18
What is this RCI?
Rehabilitation Commission.
Rehabilitation Council of India, তাই তো?
Yes.
আচ্ছা
Council of India.
Council of India.
Rehabilitation
Council of India.
India.
আচ্ছা ঠিক আছে the it appears from the submission made on behalf of the parties that the subject school is an inclusive one which permits admission of persons with disabilities. Stuff. The child of the petitioner by now, petitioner per comma, by now, comma, has been accustomed and adapted to the shadow teacher. Stop. Disallowing the shadow teacher just prior to his board examination will be extremely unfair. Stop. The child may not be able to perform in the absence of the shadow teacher. Stop. Keeping in mind the best interest of the child, comma, the court is of the opinion that the school should allow the son of the petitioner to be assisted by the shadow teacher. Stop. The matter is made returnable on 5th August 2025. Stop. A report shall be filed by the learned advocate representing the school as to whether the shadow teacher was permitted to remain present during the practical examination of the disabled child. Parties to act on the basis
My
of
lord,
this
subject to provide the disability certificate. The
Certificates are
disability
there.
certificate has not been provided to us.
But it is there from 2011, my lord.
The petitioner is directed to produce all, not produce, forward all medical documents of his son to the school positively by Monday, 21st July 2025.
Lord, maybe through electronic mail, my lord, so that I can produce it by electronic mail. It'll be easier, my lord.
All right. Both in the physical and in the electronic form.
I'm so grateful.
I'm grateful.
Call it.
The state for the respondent number 5 and 6 regarding this matter.
My lord, I am for
Central Bank of
petitioner.
India, sir. Lordship, copy has not been served upon me, your lordship. On telephonic instruction, lordship, I am appearing before your lordship. So your lordship, kindly direct the petitioner to serve copy upon me.
My lord,
1 minute. Telephonic instruction.
Only telephonic.
Who has given you this instruction?
Regional office, Durgapur.
Durgapur. Durgapur has received the brief. It is the responsibility of the Durgapur office to serve it to you. Why will the office keep the brief? The petitioner has not served only the notice. He has served the writ petition. Then?
Lordship, no doubt, but your lordship, ask them to serve.
Why? I can direct.
Expenses will be made.
Exactly. If you.
Expenses will be made by.
Right. You can make a photocopy from his brief. Why will you direct the petitioner? Why a direction will be given?
Actually, or no?
No, actually. What is the matter?
My lord, my lord, grievance is that, my lord, my residential property is not mortgaged to the bank.
The bank? Which bank?
my lord, Central Bank of India.
You are there for the bank?
Yes,
Yes.
my lord,
Then?
two application has been filed under section 14. First,
Yes.
my lord, before DM.
Yes.
And after, my lord, after filing the section 14 before the DM, they are served the notice to us. And my lord, they are demanding my residential property. After receiving the application, we are immediately made to the DM that that property is not the mortgage. Immediately, my
What
lord,
is the address of your property?
my lord, in page, my lord, 75, my lord, there have a, my lord, description of the property by ACGM. And my lord, the application before, my lord, DM, page, my lord,
Page 75 is the
ACGM, my lord. They are the
CJM. I can see. Where is ACJM? Page 75. CJM.
of the CGM, my lord.
Huh.
My lord, the description
All
of
that
the
piece
property.
and parcel of property 5779. Dag number, Khotian number.
Yes.
There is no premises number.
No premises, and my lord, not only that, this particular, my lord, property is not the mortgage to the bank.
Is not mortgaged.
Never.
And
Not
this
yet.
is your property.
Yes, my lord, this is residential property.
Residential property cannot be mortgaged.
My lord, mortgage, but my lord, this property has not been mortgaged.
This property has not been mortgaged.
My lord. My lord, the mortgage property, my lord, kindly see page, my lord. Page, my lord, 65.
65.
65, my lord, the and my lord, description of the property, my lord, page, my lord, 67.
Yes.
Page 67, my lord, collateral security. My lord, Khotian number, my lord, 254, GL number 39, Mouja Radhanagar, area 7335. Thereafter, my lord, floor number 3773833, Khotian number 1869, GL number 70, and thereafter, my lord, 3773833. My lord, totally difference, my lord, totally difference with the ACGM, my lord, order. This property has been, my lord, secured to the bank. But my lord, they are not never visited to this property, my lord. Which property has been mortgaged? They are, my lord, only the visited and try to take the physical possession my residential property.
Pradeep, সামনে থেকে শুরু. Yes.
And my lord, the description of the, my lord, deed, my lord, I annexing by page, my lord, 160, my lord, the bank document in my rate application. There have, my lord, the description of the, my lord, original deed, my lord, I-1987, dated, my lord, 74990, title deed number 169, dated 18 January 2021, and my lord, another, my lord, 577, dated 24th September 2012. But my lord, they are taking, my lord, trying to take, my lord, the property, my lord, my deed, I also annexing, my lord, page 109.
You are the owner of both the properties?
Both these property.
All right. One is a residential and the one at page 67, this is not residential.
No.
Yes.
And not only that, my lord, they are demanding the 4 crore rupees. In respect of 4 crore rupees, my lord, we are 2 times issued the demand draft 6 crore with up-to-date interest. They are not, my lord, the received my demand draft. They are not, my lord, willing to disclose my account. They are only intended to take the. Still, my lord, which property is not mortgaged to the bank?
All right, yes.
Lordship, regarding proposal, so far, as per the telephonic instruction, Lordship, the petitioner did not approach before the authorized officer. And number 2, your Lordship. Lordship, regarding the mortgaged property, Lordship, brief is not in my hand. So I cannot submit which property has mortgaged and which property has not mortgaged.
Yes.
If, Lordship, at section 17(1), if any person aggrieved by the measures taken by the 13 and or 13(4)(a), 13(4)(a) belongs to section 14. The petitioner and or the borrower and or the aggrieved person has only right to invoke section 17 before the DRT, your Lordship.
The petitioner
Lordship,
is
several
aggrieved.
judgments are there.
The petitioner
Lordship.
is aggrieved as the bank is taking steps to recover the loan amount in respect of a property which is not mortgaged to the bank. Stop. The petitioner refers to page 67 and submits that the property mentioned therein as collateral security has been mortgaged to the bank.
Before passing the order, your lordship,
The bank is taking steps only in respect of the residential property of the petitioner, at description of which is appearing at page 75 and which has not been mortgaged to the bank. Stuff paragraph. Learned advocate for the bank is not ready with proper instruction. Stop. Let the bank file a report before this court by way of an affidavit to be prepared and circulated by 1st August 2025. The matter is made returnable on 13th August 2025. Stuff. The bank, in the meantime, the bank is restrained from taking any steps in
regarding
respect
this point.
of any property which is not mortgaged to the bank. Stop. As regards the property which is mortgaged, it will be open for the bank to take necessary steps to recover the loan amount in accordance with the provisions of the
They are
SARFACI
already
Act.
filed the section 19
Well,
application before DRT.
So for the
They are already filed.
right,
Instruction
but
by
I
the
thought
police.
for yes, my
I'm
lord.
yet
We
to-
retain with the record.
Herein also it has been mentioned that the mismatch of the properties.
Yes, my lord.
Next.
I'm just.
I beg to appear on behalf of 9 to 17, I believe, almost a similar matter, my lord.
These are the matters, my
Your
lord.
lordship,
May remember.
your lordship, I am appearing on behalf of the English Bazaar municipality.
All right.
Kindly takes up the records of item number 15.
15 ta din dekhi. Item 15.
Yes.
15 কি আছে? I have started 13 because it was
এই বইটা দুটোর সময় লাগবে, হয়ে গেলে উকিল বাবুকে ফেরত দিয়ে দেবেন।
15 এর ভিতরে দেখে
এটার কপি আছে তো? 9 থেকে 17 9 থেকে 17 9 থেকে 17
Item 15.
No, 9
Yes.
to 17 are the similar matter.
Yes,
The petitioner is pressing the 15 first.
item number Amla Kumar
I believe 210 টা similar matter.
210 is also similar matter. My lord, I am challenging, may I just say what is my challenge? I am challenging a action, administrative action of the district administration by which a list has been forwarded describing our land erroneously for being declared as a waterland, as a wetland under the 2017 regulation. Now, if that wetland regulation, if it is declared as a wetland, I will not be able to make any construction there. I'll be totally losing my rights in respect of the land, and we have to preserve. That is the notification that I'll be drawing your lordship's kind attention. But first, my lord, may I show your lordship who is the petitioner? Kindly first comes to the ROR, as I have drawn your lordship's attention on the previous occasion, page 36, 37. Thereafter, I'll place the previous things. No, not 36. 51. 62, sorry, my lord, 62.
Page 62.
Kindly comes to page 62.
Yes.
62. Kindly see, this is the ROR. Tag number 388 is classified as Bastu. Mouja is Pirojpur, lordship on the top. Name is of the petitioner Amla Kumari. This plot has been forwarded as
এটা খুলে দেখতে পারো এটা এই ম্যাটারটা
Nama. Kindly comes to page 68. This is my case. Thereafter, I'll show how this has been done, what is their contention.
69 আসবে
The communication starts from page 63. Lordship is at page 63. Communication, this is the impugned communication, starts from 63. I am submitting here with a map along with list of plots involved in Chatlabil area with current land use and recorded classification
so prepared in compliance with the order passed by the National Green Tribunal on 22/3/2023. Kindly marks this order. In OA number such and such. Minutes of the meeting of the committee formed for this purpose held on such and such is also enclosed herewith. Now, my lord, kindly comes to the list at page 68. And kindly comes to serial number 12. Serial number 12, plot number 388, partly water, partly building structure, forwarded as NAMA. Now kindly comes to the order passed by the National Green Tribunal. The order is from
What
page
does
20.
this NAMA mean? A lowland or what?
NAMA, according to them, they have given an affidavit before the National Green Tribunal day before yesterday is agricultural land.
NAMA is agricultural
Yes,
land.
they have said so. They have said so in their affidavit. This affidavit is affirmed by the district magistrate. Here they have annexed everything, and low agricultural land is the
Yes,
classification.
low has to
Low
be there.
agricultural land. NAMA is low. Obviously, in respect of paddy, there has to be some waterlogging otherwise. Now kindly comes to the order, which is being sought to be invoked for conducting this exercise. Kindly comes to page 23. Order dated 22nd March 2023. Lordship is there. The present original application has been filed by the applicant alleging Chatla bill, which is a wetland in North Bengal in the district of Malda, is being encroached upon due to expansion of city of Malda. It is stated that this wetland is a natural wetland and a natural wetland purify the water of the northern region of Bengal. Now kindly comes to the ordering part. I am skipping. From paragraph 14 is the order, page 24. Considering the allegations made, we deem it appropriate to constitute a committee comprising of the following members: senior scientists, West Bengal, such and such, such and such. And 15, the committee shall visit Chatlabil and inspect the site and submit its report with regard to the encroachment alleged to have been made upon the said water body, and it shall suggest remedial measures for restoration of the said water body to its original pristine form, as well as remedial measures to ensure that there is no further encroachment. So the measures were suggested, it was directed, suggest remedial measures to the tribunal. So there was no occasion invoking this order to do anything else. Now kindly see what the district administration has done. Invoking this order, they had previously issued 2 office memorandums. Kindly comes to page 36 and 37. The committee is there, page 33, 34 is the committee report. I will be placing this. Lordship has seen the order, kindly comes to page 36. Subject compliance with the order dated such and such. In compliance with the order dated 22/3/2023 passed by the National Green Tribunal in OA such and such, in the matter of Subhas Dotto versus the state of West Bengal, he is hereby requested not to execute any deed as per order and known as Chatla bill related to the following moujas near under English Bazar municipality, Uttar Ramchandrapur, Pirojpur, such and such, 5 mojas. Pirojpur is the moja where, my lord, this particular petitioner's land is there.
What exactly is troubling you?
This was quashed by this.
This was
quashed.
Very well. Now, what is troubling you?
Next is the request to initiate and entertain any proceedings relating to record of rights. This was not challenged, so this is as of today there. My contention is that by this process, my land, which is a Bastu land or maybe Nama land in respect of others, are being given to the authority for declaring it as a Chatla, as a water body under the 2017 regulations, invoking an order of the National Green Tribunal which does not say that you have to do this. Kindly comes to
No, let us make our minds clear.
Yes.
The tribunal has directed.
Page 25.
The tribunal has directed.
There are other orders also. I'll be
The committee to inspect the site, submit a report regarding encroachment, right?
Yes.
And the remedial measures for restoration of the water
Right.
body.
Yes.
This is
To the tribunal.
To the tribunal.
Now, what has been done is that
Yes.
page 63. Acha, committee. Kindly comes to the committee report also. 33 onwards is the committee report, where of course we are not parties, we are not being heard. There are judgments which says that we have to comply with natural justice. Page 34 is the committee report, ordering part. If you the concluding part. A drone survey shall be conducted at an earliest by the district administration to get clear picture. English Bazar municipality may conduct phase-wise removal of garbage and other wastes from the instant location for restoration of the instant water body, and it may also set up STPs to prevent such and such. Demarcation of boundary of the waterland along with the geo-mapping is to be commenced by the district administration with the help of the Department of Fisheries and Department such and such for removal of illegal encroachment and restoration of the said water body. District administration will take necessary steps. District administration may initiate process for declaring the Chatla bill as significant wetland as per the Wetland Conversion and Management Rules 2007 and send the proposal for such notification to the concerned department. Now, my lord, my humble submission is that if this was done only invoking order of tribunal, and in the first round of litigation day before yesterday, I have, my lord, moved a matter where the contention which has been upheld by this honorable court in the other judgment, saying that until this declaration is there, the tribunal will not be assuming jurisdiction with regard to any matter. That is the contention in the first petition. Now, my lord, only because we had taken up this contention so that we cannot further take this contention, this entire process has been initiated. Second is that I would not have stood if the area which is marked as bill may have been given. Obviously, it is a bill. Bill has to be recognized. If they don't want to do, I will not stand in the way. But areas where persons have, my lord, acquired interest, which is not a bill, maybe NAMA, under the law as of today, there is no bar by which NAMA cannot be converted to Vastu. So there are many people who have invested their life savings to acquire a particular plot of land, which is NAMA, which they have some in
Listen,
this
as
case.
of now, you cannot have any reason to be aggrieved.
Is because if this particular now kindly comes to the notification. I understand. Kindly notification does. Notification does.
92.
আমারটা 63 এখানে 60 হবে
Kindly.
96.
2017 rules.
এই তারপর 96 বের কর।
ও আচ্ছা
তাহলে the rules. Yes. Kindly takes this.
Yes.
These rules are, my lord, wetland rules, which they are now trying to come under by way of a declaration. Wetland G is wetland. 3. Applicability of the rules. First is Ramsar Convention. Second is notified by the central government, state government, and the union territory administration. Restrictive activities are wetland shall be conserved such as the following activities shall be prohibited within the wetlands, namely conversion from non-wetland uses, including encroachment of any kind, setting up an industry and expansion of the existing industries, manufacture or handling or storage or disposal of construction demolition wastes covered under such and such, Solid waste dumping, we are not doing in any case. Discharge of untreated waste that the municipality is concerned. Any construction of a permanent nature except for the boat jetties within 50 meters from the mean height floor level observed in the past 10 years calculated from the date of commencement of this rule, poaching and other. Now, if this is declared as a wetland, I will not be used to use my land. That is troubling me. And in doing so,
you are still at the apprehension stage because it has not been declared.
I have.
The wetland has not been demarcated also in the last matter you were saying.
They are saying that we have conducted the work of demarcation. This is the list, kindly declares.
All right.
So at that stage, I am before your lordship because they, while doing this process, could have given me an opportunity of hearing, calling me. They have not done so. And the entire process, in doing so, they are invoking an order of National Green Tribunal which doesn't direct them to do so.
It is only for the purpose of identification and demarcation of the wetland that all these things are being done.
Now, my lord, submission before the NGT is that they have sought for approval, and moment this my lord notification is made, regulation 4 will be invoked. So the entire process is there without any opportunity of hearing, without hearing me. It is my land, and while forwarding, they are forwarding Bastu as Nama. I have shown, I have other matters also where I'll just show, my lord. I have prepared a chart. In respect of item number 9, lordship may not be troubled. In respect of item number 9, Nama stroke Bastu has been forwarded as Nama. In respect of item number 10, Bastu and Bastu, two my lord, dag numbers have been forwarded as Nama and Bastu. In respect of item number 12, Nama at present Bastu has been forwarded as Nama. And item number 13, Nama Bastu has been forwarded as Nama. 14, item number Nama Bastu has been forwarded as Nama. 15, Bastu recorded in the ROR has been forwarded again as Nama. 15, I am placing before Lordship Amla Kumari. 16, Nama has been classified and mentioned and Nama forwarded as Nama. 17 is Bastu recording in the live data has been forwarded as Nama. Stroke bill. And last is 210, Nama has been forwarded as Nama. So my humble submission before your lordship is, before my rights in respect of enjoying my land, these are all middle class persons who have invested their life savings in procuring a plot of land, saying that if the plot of land is, my lord, they can use it for their future purposes. Now, my lord, their valuable rights are being inflicted, my lord. They will not be able to do any construction.
All right, let me hear.
And my lord, I am being, my lord, prompted to draw your lordship's kind attention to page 64. Kindly comes to paragraph 3.
Yes.
This is, my lord, A, minutes of the meeting of the DM. 3. A brief document regarding Chatla bill had already been sent to the West Bengal State West Wetland Authority via memo number 49/2024. That is at page 85. However, a fresh brief document would be prepared by the such and such, incorporating economic aspects of the water body, such and such further. So therefore, they are in the process.
All right, I followed it.
Moment 67. Yes, and 67 is also a point. Kindly sees how things are being done. This is 67 is the person, they are the persons who have prepared the chart. Kindly, lordship is at 67. Kindly sees the date at the bottom. 25th February 2024. So on that date, now kindly comes to the first page, first line. In pursuance of your order dated such and such, 5th December 2024. So in February 2024, they are quoting an order of 5th December.
Maybe it was 23 wrongly gone down.
And thereafter 23/9/2024.
I have followed it.
So this is, my lord, the process that they have followed.
All right.
Entire process is without. I have judgments to say.
1 minute.
That
I
the
want to
action
know
justice has to be
the
followed.
state that if a land which is recorded in the name of over here or the maybe the petitioner or maybe any person
Here petition. Others.
as Bastu or something else, but not a water body, but thereafter at the process of demarcation, it falls within the water body. Will these persons be provided any type of compensation first? And whether if you infringe their right to property, whether any opportunity of hearing be given to them or not? Two queries.
But first query, I cannot answer right at this moment. I require some time to minute time. But so far the second queries are concerned, Lordship kindly take trouble to see the page 96 once.
96 in my brief, right?
Yes, yes.
Yes.
Now 96 will Lordship see
Hmm.
this is the notification, date of notification, draft notification, name of the such and such process in the exercise of the power conferred in the rule such and such wetland. Rule 26, kindly skip over the for moment, then kindly come to the second part.
Yes.
Possibly this is not matching.
No, it's matching. Rule 7. I want to see what Rule 7 is.
Yes.
Delegation of powers and
Delegation.
functions to the state government and union territories.
So that there is no confusion, the power is there. Now kindly, yes.
Yes, then.
Yes, then any person interested in making any objection
Right.
or suggestions
Hmm.
on the proposal contained in the draft notification may forward the same in writing for consideration of the state government, UT administration, such and such. So specific or
There is
at
a
mail address.
provision to give objection.
Yes. So far today, as on today,
No
nobody has
objection.
come.
Relying only on some
All right.
And so far, Lordship would.
And whether this draft notification has been published?
No. Draft
Then
notification. This is what I am saying. And Lordship, I am pointing out one more interesting thing. Mr. Lahiri is relying upon one particular document. This document, this particular document, which is in my brief, is at P6. Kindly have a look.
page.
Possibly page 63 is not matching up with my brief. Kindly.
You are in item 15.
I am in
Item 15. Yes.
May I just address your leadership on a very short?
I was hearing him. I'll hear him and then I'll come to you. All right.
Now, this is, Lordship would see the nature of the communication is internal in nature. This is not published to the any other person. This one. So this is the internal communication of the department. I do not know how this has been came into the limelight or otherwise.
All right.
This is the first question. Second question is that, Miller, since the draft notification has not been published so far, question is that is it not the premature application?
I get it. Yes.
The first point is premature, but I will take your leadership through other points also.
I may
Why-
take your lordship short.
Why it is premature?
Not short. You can take long. It's too.
Chief is
Go. Go.
What has been already submitted that it is in a process of Millard being notified as a wetland. So Millard, there is, I take your leadership to the first point is that whether it is a Bastu or bill or whatever it is, and if they say that it cannot form Chhatra bill, that is an objection to it being declared as wetland and not the classification of the land. If they are agreed with the classification or wrong recording of the classification, LRTT is the remedy. They should approach them. Number one. Number two is.
No, they say it is rightly recorded. They don't say it is wrongly recorded.
So they say that these lands cannot be notified as wetlands. So they have an objection.
They say not yet been notified. So prior to notification, they should be given an opportunity of hearing to raise an objection.
Kindly comes to rule 7 of the rules, which has been
Yes.
handed over to your leadership. Delegation of power, your leadership had a brief on
Yes.
this subject.
Right.
The concerned department of the state government or union territory administration shall, within a period of 1 year from the date of publication of these rules, prepare a brief document for each of the wetlands identified for notification, providing so and so, demarcation so and so. This was shown to your leadership. Number 2, based on the brief document, step 2, the authority shall make recommendations to the state government or union territory administration for notifying the wetlands. So recommendation has to be made after brief document. There is no publication. Thereafter 3, The state government or union territory shall, after considering the objections, if any, from the concerned and affected persons, notify the wetlands in the official gazette. They can be prejudiced only if the notification is there. It is premature. They must wait for it. And one last thing kindly comes to the impugn notification once at page 63, probably it is in your ladyship's brief. Kindly, that is, they have asked for prayers against this 7th of April in another one, and in this one it is also 7th of April, yes, same. Kindly peruses it once. It is a communication from District Magistrate Malda to Member Secretary. I am submitting here with the map along with lists of plots involved in Chhatrapati area with current land use and recorded classification. So prepared in compliance of the order passed by so and so. The minutes of the meeting of committee formed for this purpose is also enclosed herewith. This is for favor of your kind perusal. No step has yet been taken to be suggested. There cannot be any apprehension. It is a interdepartmental communication. Thereafter, my lord, these process under 7.2 can be complied with. Thereafter, if without the consultation or giving them an opportunity, this is notified, then they can have a cause of action.
Now, my lord, my contention is that everything has been initiated pursuant to, according to them, pursuant to order of the tribunal. Tribunal said that something has to be done before the tribunal. So therefore, and the Supreme Court has stated, my lord, in judgments, my lord, says that tribunal has to adjudicate. It is an adjudicating authority.
No, right now, no adjudication has taken
It has
place
to
at
be
all.
placed before the tribunal. They could not have gone before the member secretary. For now, what they are trying to do is, kindly see, Malad, this is the
Who is trying to do?
Yeah, they have said so. This is the affidavit of the tribunal before the tribunal. They are saying that everything has been done.
You're seeking for final approval.
They are seeking for a final approval before the tribunal.
Cannot be done. Let them do, then you can come. As of now, what
My
is your
contention
cause
is
of
that
action?
if as of today it is declared, then I'll be prejudiced.
It cannot be declared because
Kindly consider.
this rule
I
says
understand.
about an objection.
This process has to be done before the tribunal. Tribunal will consider as to whether these Malad plots are at all can be constituted under the wetland. Tribunal will consider the RORs. The Malad tribunal has directed production of RORs. Kindly see the second last order of the tribunal. Tribunal last order. The tribunal is supposed to consider, and it has already directed the previous order that you produce the RORs. So the adjudication has to be done by the tribunal, and the tribunal has initiated a process saying that kindly you suggest the remedial measures. They should have approached the tribunal saying that these are the remedial measures. These are the RORs, record of rights. Tribunal will will adjudicate. That is the Malad law. Tribunal has to adjudicate. It cannot be, the tribunal cannot delegate its power, my lord. Kindly, my lord, seize the last order of the tribunal once.
The petitioner
Kindly seize, my lord, the order of the tribunal.
Not claims. The petitioner is a recorded landowner in respect of a certain plot of land, which is recorded as বাস্তু, এটা আইটেম 15, ঠিক আছে? প্রতিটা মামলাতে আলাদা রেকর্ড অফ রাইটস থাকবে। এখানে ওরা একটা চার্ট দিয়েছে।
My lord, before passing the order, kindly, my lord,
একটা চার্ট দিয়েছে, এখানে বাংলায় লেখা আছে বাস্তু।
এটা কি?
ঠিক আছে, তো যেটার যে ক্লাসিফিকেশন থাকবে সেই ক্লাসিফিকেশন লেখা হবে।
Kindly takes up their affidavit day before yesterday that they have filed. Affidavit, third paragraph, kindly come. That in the said solemn order, the honorable third paragraph, Lordship is there. The honorable tribunal has been pleased to observe paragraph 2. There is not a single document to record on record to show as to whether the area of Chhatrapati is recorded in the revenue records as a water body, irrespective of whether or not it has been declared as a wetland under the such and such act. Mr. Shivajyoti Chakraborty, Learned Counsel for the state respondent, is directed to file affidavit bringing on record the appropriate revenue records showing the nature of the land which is otherwise known as Chhatrapati. Now, my lord, kindly cease. This they were supposed to give before the tribunal. This is the land records, because there has to be adjudication before all these things. The authority, my lord, they are the the state respondents must file affidavit with the revenue records showing the plot numbers of the entire area of Chattabil to show what is the nature and character of the land known as Chattabil. So this they have to show before the tribunal. Tribunal will adjudicate. Thereafter, they can continue with the. I would have understood that they are not quoting anything from the tribunal. So they have to, my country kindly appreciates, my lord. They are proceeding on the basis, erroneously proceeding on the basis that there is an order of the tribunal to do this thing. Whereas the order doesn't say anything. So therefore, without doing so, they are, my lord, doing this, bypassing the tribunal, my lord, bypassing the, my lord, and my lord, prima facie I have shown, my lord, Vastu is being forwarded by as Nama. This is their record. How can, my lord, this is prima facie error apparent on the face of the record that my.
The petitioner is recorded on a landowner in respect of a certain plot of land which is recorded as Vastu.
Vastu in the record of rights maintained by the state administration. Now, by the land department. The petitioner is apprehensive that the petitioner apprehends that the Vastu land of the petitioner may be treated as a wetland without affording any opportunity of hearing to the petitioner. Stop. Reference has been made to the order dated 22nd March 2023 passed by the National Green Tribunal, Eastern Zone Bench, Kolkata in original application number 30/2023/caps EZ in the matter of Subhash Dotto, DATTA versus State of West Bengal and others, wherein there is a direction upon the committee constituted by the tribunal to visit and inspect the site of Chhatrabil, CHATRABWL, and submit its report with regard to the encroachments alleged to have been made upon the water body, and it shall suggest remedial measures for restoration of the water body to its original pristine form, as well as remedial measures to ensure that there is no further encroachment over the water body. Stop. The learned counsel representing the petitioner submits that as on date, the records of the subject land does not suggest that the land is a water body. And accordingly, the tribunal could not have entertained any petition in respect of the subject plot of land. Paragraph. It has been submitted that the petitioners have not been involved in the process of identification of the water body. Stop. The petitioner purchased the subject plot of land with valuable consideration and will not be able to use and enjoy the same if the same is classified. Now, if the same is classified as a wetland. Stop. According to the petitioner, the proposal for conversion of the classification of the land is nearly over, and there is every possibility that the proposal to change the classification of the subject land will be approved by the authority. Prayer has been made to restrain the respondents from taking any steps for converting the classification of the subject land. paragraph. Learned advocate representing the state respondents
I'm
submit
relying on this
upon
judgment also.
instruction that the writ petition is a premature one. Stop. There is no cause of action by which the petitioner can be aggrieved at this stage. Stop. The provision of Rule 7 of the Wetlands bracket open conservation and management bracket close rules 2017 has been placed before this court. The same mentions that the concerned department of the state government or union territory administration shall, within a period of 1 year from the date of publication of the rules, prepare a brief document for each of the wetland identified for notification. Stop. Based on the brief document, the authority shall make recommendations to the state government for notifying the wetlands. Stop. The state government shall, the state government shall, after considering the objections, if any, from the concerned and affected persons, notify the wetlands in the official gazette. Stop. Next. It has been submitted that as on date, the draft notification has not been published. Stop. As and when the state takes a decision for notifying the land as a wetland, the petitioner may file any objection. Stop. Paragraph. Upon hearing the parties and on perusal of the documents placed before this court.
I have said that it should be before the tribunal.
Issues?
They should have approached the tribunal for adjudication relying on the judgment. That was also my
Adjudication of what?
adjudication of the rights. They should have, because the tribunal wanted that they should give a remedial measure to the tribunal. Tribunal didn't direct that they should directly go to the wetland authority for demarcation. That is also my contention. And since they should have approached the tribunal and tribunal should have adjudicated.
I fail to understand. See, the court says, the tribunal rather, the committee shall visit, inspect, submit report regarding encroachment and suggest remedial measures. What steps they have taken?
Remedial measures have to be suggested to the tribunal.
Yes.
And thereafter the tribunal will consider. Well, the tribunal now they without going to the tribunal and suggesting remedial measures along with the RORs. Last order that has been quoted by them is that there is nothing on not. The tribunal says there is not a single document on record to show as to whether the area of Chaptraville is recorded in the revenue records as a water body.
Yes.
Irrespective. So therefore, it was directed that the learned state advocate should approach the tribunal with the record of rights and the records.
They will approach. They will approach. Where is the difficulty?
Departmental communication department.
This is the final approval.
The tribunal will take care of it. Why will this court go into?
Putting this particular thing, if this subsequent notification is issued,
it cannot be done, sir. It has to be upon an objection. Whether the court adjudicates or not is separate. It is your personal property. You have a right to object. You will file your objection as and when called for.
I will be missing an opportunity to substantiate before the tribunal that this entire exercise could not have been carried on.
Then that is a separate forum. You go before the tribunal. No, that cannot be.
I will be losing that opportunity before the tribunal.
The parties
and the Supreme Court says the tribunal has
yes.
Hearing the parties and perusal of the
report.
Yes. আবার বলুন
sorry my lord I
sharing the party perusal of the documents before this court.
It appears that as on date there is no order, decision notification from any competent authority declaring the land of the petitioner as a wetland. Stop. According to the subject rules, there is a provision for filing objection prior to the declaration of the land as wetland. Stop. The said process has not begun till date. Stop. The petitioner relies upon certain documents to suggest that the committee has directly approached the state government for declaring the land as a wetland. Stop. According to the court, the conception of the petitioner may be erroneous. Stop. Law does not permit declaration of any land as a wetland without granting any opportunity to the affected person or the concerned person to submit objection. Stuff. Next. The matter is already pending before the tribunal. Stop. The tribunal has directed the authority to visit and inspect the site and submit its report. Stop. The tribunal shall proceed to decide the issue after hearing all the parties. Stop. The writ petition stands disposed of.
At liberty to approach the tribunal in that case, my lord. I have to.
Always. Who is stopping you?
This is not, nobody is taking away.
Particular.
Nobody is taking away.
Why I am saying so? In the tribunal, we are not parties.
Go and make application.
Specifically, Supreme Court says that you have to
It'll
admit
not
it upon giving opportunity.
Grateful, your lordship.
Grateful.
But if your lordship wants, I am relying upon my lord. Kindly request if your lordship. In the lordship judge, paragraph 21.
No.
Only one my lord.
Oh, sorry. এটা থাকবে। Give
Publish
me that chart. দেখি এই চার্টটা।
Chart I have handed over.
Call one by one so that the learned council's names can be given.
নামটা দিয়ে দাও ভাই।
সবকটা স্টেটের খাবার দিয়েছো তো? আচ্ছা ঠিক আছে।
Your lordship, my name may kindly be recorded.
Yes, municipality.
Yes.
আচ্ছা।
Grateful, your lordship.
এটা হচ্ছে কোত্থেকে শুরু হলো?
9 থেকে 7
9 নম্বরেতে ক্লাসিফিকেশন দেখে নেবেন আছে নামা,
নামগুলো
নামা, বাস্তু, নামা। বাস্তু মানে নামা নয়, এখানে নামা লিখেছে, নামাই লিখবেন।
Your lordship, your lordship, I may be pardoned to mention serial number 48. Today, the division bench, honorable division bench had.
কোনটা? কেন থাকবে না কেন?
Interim stay was granted till today. Honorable division bench had been pleased to direct your lordship to grant it till September because he had agreed.
Show me the order of the division bench.
Today itself it was passed, your lordship. I cannot.
But then the division bench has passed order.
Today.
Then where is the difficulty?
No, they did not extend the interim stay. He has accepted to withdraw all the cases today before the honorable division bench, but for extension, the honorable court has told me to come before your lordship.
Which item?
48 serial number.
48.
State pleader was there, your lordship. If
who is the state counsel?
Yes, lordship. I am led by Mr. Devasis Banerjee. We have the respondent number 1, lordship, High Court Administration. Yes.
You respondent number 1?
High Court
Administration. Yes.
Yes, lordship. There is a liberty to petitioner to extend the interim order, lordship, before your lordship.
Bring the your objecting party. Otherwise, there will be a writ petition filed against the court.
Your lordship, it has been. Your lordship, it
I
has
will not pass any order in their absence. Please bring them. I will pass order.
It has been recorded in the order of the honorable division bench
If
that
it is
they
already
had.
there, then that is there.
No, that he will have no objection if interim
If
stay.
it is recorded,
Yes.
then you are protected.
Yes.
Where is the difficulty?
But interim stay is not extended. Rest of the things were
The
done.
other side.
Yes, your lordship. I'm trying to bring.
Yes. Milord,
Don't forget to take the book. Whose book it is? Don't forget. Yes. Yes.
But please don't skip your lordship's lunch.
I have had
Self-inflicted.
I have had it and I'm not going to rise now.
Heavy breakfast.
3:30 today, Milord.
Yeah, that is better.
The lordship has become workaholic, Milord.
Become?
Workaholic.
Milord, I have always seen my lord like this only.
Why this back?
I don't know.
He has also
My
seen.
lord is senior brother.
No, he has also seen. Yes.
Milord, I have taken instruction. First of all, Milord, maintenance charges are due and payable.
All right.
That is why, Milord, the no objection was not granted. Second, Milord, out of 48, 31 has already been elected. There is no possibility.
Elected?
So unopposed. That with nomination filed, the last date gone. So number one. Number two, Milord, 17 seats remain vacant out of 48. If the authority, competent authority finds that the entire procedure, Milord, is tainted with malafide as urged by my learned senior friend, Milord, the 17 seats will be filled up by them. Why they have come? Milord, the moment they find that if they could have filed their nomination paper, they could have been elected as unopposed candidate. Now, Milord,
Contest will be there.
They no unopposed.
The balance.
No.
For the balance, 17.
192 number of flats, 48 seats in the board. 31 has filed
Unopposed.
nomination, unopposed. Now, Milord, the old committee, Milord, the term expired, Milord, way back in Milord, February or March. That is what Mr. Dhiraj Trivedi, my learned senior friend, can say.
Senior friend.
No, Milord, cheers. The institution.
I've grown
No,
up
Milord.
seeing him as my senior in law college, Milord.
Milord,
Whatever
I have
Bengali
to show respect.
I've been inspired by him. Now
He is a designated senior advocate.
My lord.
না মিনা এরকম বলিস না
না এটা
ওর বয়স হলেই সম্মান আছে মিলেট কাইন্ডলি মিলেট why you lordship
বলো Milord, where I am wrong, Milord.
চুপ কর না
আরে বলো
so Milord, so today Milord, if your lordship Milord grants any stay today, why I tell your lordship Milord, then Milord, your lordship is trying to Milord giving a rebirth to Milord the committee that has already gone, a new committee Milord out of 40, 31. If the authority finds within a month or 15 days that the entire exercise is bad or they should have been provided, Milord, this gentleman Milord has failed Milord to deposit the maintenance charges, 50,000.
That is one.
My lord,
that is the
my lord,
next
this is
one.
no. My lord,
1 minute. I'll hear you. Wait.
That is my instruction.
I'll hear you. Thing is, that is the second
the
matter.
case, for subject to correction, Milord, what
In
my
the other
senior
matter
friend,
also?
yes, two matters. That is why Milord, they came before your lordship on the day, my client's instruction, subject to what my lord say. Milord, it is not in the hands of my learned senior friend. I tell your lordship, Milord, the moment they finds that this is the 17 seats remain vacant, there are no other contested. If I have filed, because there is no morsel of proof or semblance of evidence, either in the writ petition, in the pleading with evidence, or Milord in the letter, that they wanted to file nomination.
My pleading is there.
That is later afterthought.
No,
Because you wait. The moment you find that 5 p.m. he said on 25th June, you came to know about the position that unopposed 31. That moment you felt that if you could that this is our opportunity and we did not avail it. So I will come before the constitutional court and the court will come in aid of that is the perception. Because he has made out something today, Milord, in the writ petition. This needs to be this disputed question of fact.
Yes. This has to
So
be
today,
adjudicated
what
by
is
the authority,
so
no
today,
doubt.
Milord, today, if there is no election on 20th July, as Milord urged, if the committee, if they declared the committee Milord unopposed 31, 17 remains vacant. It is not that they will not be accommodated. If the authority finds that yes, there is an injustice, then Milord, absolutely. Then Milord, the issues that are left to be decided are not justiciable by the writ court. Because I have never seen Milord.
My lord, reply 30 seconds, Milord.
তুই এক মিনিট
No, I'm 1 minute না করো। Matlab, kindly come to my paragraph 15, page 11. It's not an afterthought, it has been pleaded. I have pleaded specifically.
All right, wait. State.
Yes. He is still to make submissions.
No. Submission is I have paid money.
No, my lord, not only that, my lord.
Not
As far as the allegations my lord, are the concerned, submission that has been
Go on minute.
as far as the allegations and counter allegations are concerned,
That is for them.
that
They are
is
not.
for them. But
Yes.
we have not taken as yet,
Yes.
as far as the little instructions we have received, as yet no step
Steps
has
have
been
been taken. Right.
Kindly, if my lord is pleased to, grant us time, we will consider all these allegations, counter allegations, everything.
And the steps taken in the election shall abide by the result of what will be your
Alternatively,
your
yes, representative can oversee the election as well.
oversee election will not do because he have not been able to file his nomination.
And they have already elected.
Not only that, my lord. Many 30
your lordship
seats have been elected.
your
out of
lordship
this.
then your lordship has the authority to induct an administrator for the posts which remain uncontested or say that
No,
election is not conducted.
What will happen to these unopposed candidates? They will become the members.
These are the yes men of the president.
Nobody was allowed.
We were not allowed to participate. As far as I get, yes men have been nominated. That has been made. As far as I get from the second writ petition, he wished to file nomination, but his nomination probably has been cancelled or maybe
Not accepted.
not accepted. So he was a contending person to contest the election.
Right.
If he was allowed to file the nomination, he could have also become an unopposed candidate, and as well as for the petitioner number the first petitioner.
So the best thing that can be done is you consider the objection after giving hearing to all the necessary parties.
Yes.
And any steps taken in the election shall abide by whatever
The election remains incomplete.
It is incomplete. Whatever remains. Sunday is the election. The others will be there.
No, there will be no election.
There cannot be an election.
There cannot be election.
We can choose their yes men.
Whatever it is will abide by the result of
Yes, my existence is subject to his decision.
even the unopposed candidates also.
Our domain, as far as today is concerned, is with regard to only two allegations of two persons. So I do not find that whether we can go into the domain of the entire election as well. If your lordship grants us that liberty, we will. But as of today, we have received only two complaints from two individual persons.
Justice Bhattacharya's judgment is in the teeth of the situation, which holds that they have the right to oversee and even suo motu take steps and remove the committee. Now, my lord, they have wide powers, my lord, which I have placed before my lord. My learned friend is saying that.
When the president have a due,
if my lord,
his maintenance, my lord, this is the allegation.
My lord, no board meeting was held.
No board meeting was held. He has not paid.
No board meeting was held. Only 31 pick and choose people were there. My lord, I have stated categorically in my petition that I was not allowed to sign in any nomination. It is in paragraph at paragraph 15.
With 192 members in the entire association, such a lot of fight. What is going to happen to the state and the district and the country?
Millard, I tell you, lordship, in Bengali we say, যত বড় সংসার তত বেশি ঝামেলা।
দাদা মাইক নিয়ে তুমি জোরে বলে দিতে আমি বলতে পারছি।
এই অর্ডার নিচে বিরক্ত করে।
My lord, in my respect,
Millard kindly cease their prayer. They wanted consideration.
This should be there. Let him give all.
No, this is Millard, absolutely not.
my lord,
who have the dues or not, and thereafter give the nominations.
Yes. No, I oppose.
my lord,
I oppose.
my learned friend appearing for the state, he's not posted with the facts. There are so many number of letters which are lying
There
with
are
them
51
unattended.
These are not part of the records. I don't know.
These are probably not.
My lord will say endorsement of.
You have not annexed it.
I am not.
As far as
Now the entire people have come now. He has come.
51 persons have been rejected the nominations on flimsy ground.
As regards the election also, there is an objection. So
if
that
there are,
will be good.
then
My lord, they don't even know.
This is not the part of record.
today
These are not, yes.
We got the brief just now.
My lord will kindly appreciate. My lord, he is representing.
If my lord starts appreciating, then my lord, all other apartment owners will come. Lord, আমাদেরটাও দেখুন।
আরে দাদা, এটা কোনো
আচ্ছা।
My lord will kindly protect.
May I take my lords kindly?
Yes, the matter.
My lord will at least protect me, my lord, because I have not been allowed to sign
Please
my.
secured, my lord.
How I am secured?
given the chance to file my nomination also.
All right. The matter relates to the sunrise, to the owners and members of one Sunrise Towers apartment.
Localizes Sriti Rama.
My lord, may I make
Stop.
one more submission, my lord?
No, no,
My lord, the AGM has to be declared after a board of meeting was held. There was no board of meeting was held
Alright.
for last 6 months.
All right. আচ্ছা Sunrise Towers apartment বললাম তো the Sunrise Towers, it is named as Sunrise Towers. Sunrise Towers.
Sunrise Towers Owners Association.
No, that is
Apartment
the association.
Apartment Owners Association.
No, that is
Sunrise-
the association.
Yes.
The
Building.
complex is
Yes,
Sunrise Towers.
Sunrise Towers.
Sunrise Towers. ঠিক আছে? The writ petitioners allege that they have been
ঝামেলা হবে।
Well, petitioner number 2 has a different allegation he had made. He was not allowed to participate as well as sign his nomination.
Paragraph suspended.
Huh.
He has come up before this court to revoke his suspension.
No, I have not come. He, my learned friend, is not well versed with the.
You are Narendra Kumar Gupta. You
My lord,
are
I am.
only
I have-
one petitioner.
Yes, my lord. One petition.
One petition.
One petition.
You also one petitioner.
One petitioner, Vinod Kumar Shukla.
All right. Petitioners.
No, no,
petitioner. The petitioner was. The petitioner has been suspended from the association. Stop. Challenging the suspension, the petitioner approached the competent authority under the West Bengal Apartment Ownership Act 1972. Way back in December
9th, 2020.
2024. Stop. The said complaint was never disposed of. Stop. In the meantime, the Sunrise Towers Apartment Owners Association has declared an election. Stop. The petitioner intended to contest in the election process. But because of his suspension, he was unable to do so. Stop. The election is scheduled to be held on 20th July 2025. ঠিক আছে? তারপর হচ্ছে যে learned advocate representing the association submits that the petitioner never sought to submit his nomination for contesting the election. Sought, S-O-U-G-H-T. Submit his nomination for contesting the election.
Paragraph 15, we have stated that we are not allowed.
Election. The several allegation না never বললাম কি বললাম never sought to ঠিক আছে contesting the election the contesting the election. Stop. The court ought not to enter into disputed questions of facts raised by the parties. Stop. The learned advocate representing the state respondents submits that the objection filed by the petitioner is pending consideration. ঠিক আছে? Next. After hearing the parties, it appears that the objection which was filed way back on 9th December 2024 ought to have been considered by the authority. Stop. The authority slept over the said objection for more than 6 months. Stop. The election of the association is scheduled on 20th July 2025. Stop. As the petitioner is a suspended member, he has not been allowed either to contest the election and he will also not be allowed to cast his vote. Stop. The entire election process will stand vitiated if ultimately the allegation made by the petitioner is found to be proper. Allegations হবে ঠিক আছে In view of the above, the competent authority under the West Bengal Apartment Ownership Act, 1972, is directed to consider and dispose of the complaint lodged by the petitioner in accordance with law after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order. Stop. The allegation of declaring the election as bad and illegal shall also be considered by the authority. Stop. If the competent authority comes to a conclusion that the process of election has not been conducted properly, then necessary remedial steps shall be taken by the authority. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 30 days from the date of communication of the order. Stop. The fate of the election to be conducted on 20th July 2025 shall abide by the decision to be passed by the competent authority in this matter. Paragraph. Learned advocate for the petitioner is directed to forward to the competent authority all the objections/representations filed before the authority at the time of communicating the order of the court. Learned advocate for state respondents is also directed to communicate this order to the authority. Stop. Writ petition stands disposed of.
One innocuous premise. My suspension will also be considered by them because that was the main contention. My suspension.
The issue of suspension of the petitioner shall also be decided by the authority.
My lord would record the submission on behalf of the respondents, my lord, association, that they had not made any contention regarding the election in their complaint before the competent authority.
Oh, there are documents.
You know, there are separate complaints. These are not part of
During election.
The particular complaint.
That is the reason the court has directed him to forward everything where seals are there. Suppose he makes up today an allegation, then that will be different. These objections are already there with the authority.
Pertaining to the petitioner.
Not pertaining to the petitioner, there are other allegations. They will the authority.
My learned friend is not. He has not gone through my my petition.
Supplementary affidavit.
My
এটা
lord,
হচ্ছে 1600-095.
Not a semblance of allegation regarding the election in their complaint.
Election, my lord, complaint by that was not there. My complaint is in December. I cannot. I am not a.
My lord, only
They have not filed this in representative capacity.
My lord, 48 people have been made. Order 1 rule 8 has been followed.
My petition, my lord.
Yes.
My lord, only
But
one
in
thing.
my
Hey, no,
petition,
X second.
I have made specific complaints.
That is the
regarding
second.
non-
That is the second. That is the
AGM
second matter.
notice.
With regard to the first matter, my lord, I have one thing. It has recorded that that is pending consideration of the representation file. But with regard to their representation, we have written to the petitioner that there are counter allegations by the people representing the association. We have already forwarded that on 7th of July.
Yes, but thereafter?
Thereafter, nothing has been done, but the counter allegation has already been.
That is the reason the allegation,
7th
counter
of July.
allegation, everything has to be considered and then pass a decision.
Kindly
Less
record
said the
that
better.
allegations and counter allegations.
Less said the better. 4th of February they received
I
the
have
reply.
directed hearing to all the parties, which includes the counter allegation. কি বললাম বলুন তো ওখানে শেষের দিকে directed to consider the dispose of the
directed to consider and dispose of the complaints lodged by the petitioner in accordance with law after giving reasonable opportunity of hearing to all the necessary parties by passing reasonable.
all the necessary parties and the complaints lodged by the private parties. So everything gets covered. এই জাজমেন্ট দেখানো হয়নি, ফেরত দিয়ে দিন। এফিডেভিট অফ সার্ভিস রেকর্ডে রাখুন। ইয়েস, হোয়াট ইজ ইয়োর সাবমিশন? হ্যাঁ, ওটা ফেরত দিয়ে দিন।
এখন তুমি বলো যাবো।
The original documents are there, the letters and everything to be forwarded. What is your submission?
I have paid all my dues.
ও আরেকটা জিনিস, আর একটা জিনিস এই অ্যাসোসিয়েশন বলেছে দেয়ার আর ডিউজ মেইনটেনেন্স ডিউজ, ওটা লিখে দেবেন দুটোতেই, ঠিক আছে? the maintenance dues to be filed to be submitted by deposited by the petitioners. Yes.
Well, I have paid all my dues.
Acha.
That was common maintenance. Now the authorities, that is the president, is giving a supplementary bill.
Aha, all these things before the authority. This court is not deciding the bills. Then
My lord, then the AGM notice was not served to all.
everything before the authority.
With regard to the second matter, my lord, our engagement has to be one line.
Regularized?
One line.
Acha. None appears on behalf of the state respondents. Eta hocche item 3. Binod Kumar Shukla 16193. Appears on behalf of the state respondents despite service. Stop. Affidavit of service filed in court is taken on record. Stop. As the allegation in the instant writ petition is similar to the allegation
To be abided by.
in the matter of 16095/2025 Narendra Kumar Gupta versus State of West Bengal and others. Accordingly, the learned advocate representing these state respondents in the said matter is requested to enter appearance on behalf of the state in the instant matter. Stop. The government pleader is requested to regularize the engagement of the learned advocates representing the state in this matter.
My lord, since my lord has already said, my lord, I apologize, my lord, that outcome of the election, my lord, they have, my learned senior had submitted, my lord, that there will be no election because already nomination has been done. I mean to say, election has been done, my lord. So my lord will record that one line, my lord.
Why?
Because 20th, according to his submission, there will be
Yes.
no election, there will be no casting of vote. He's saying 31.
May not be the entire election process will be under the scanner of the competent authority. He can take remedial measures if he finds that
Including
the
these
process,
17 elected persons.
process is
Including these
Acha,
people.
thik ache,
Yes.
including
these
the
17
persons who have
who have
already been declared elected
Yes, my lord.
uncontested.
My হয়ে গেছে আর বলো না বকা খাবো
দুটো আলাদা order না একটা order?
কোনটা? না না association.
And my lord, respondent number 26 has been wrongly impleaded, my lord, let it be expunged.
In your matter?
Yes, my lord. Respondent number
1 minute.
26.
আচ্ছা, আর যেখানে বললাম ওই যে the election process of election will abide by the result of the decision to be taken by the authority, including the election of the uncontested
17.
members.
17 and
17 uncontested
17,
members.
31 members.
31.
আচ্ছা 31টা 31 uncontested members. দুটোতেই। আচ্ছা আর
Respondent number 26.
Respondent number 26 has been wrongly impleaded. প্রথমটাতে Respondent number 26 has been wrongly impleaded. Expunged. Yes.
My lord,
I am
there is
grateful.
my objection to this, that to the extent that, my lord, with regard to the election of the other candidates, first of all, my lord, there was no contention.
Raise all objections over there, please.
And
next,
secondly, my lord,
My lord,
remaining
I'm grateful.
seats, they are to be elected, my lord.
আচ্ছা সব
Has come, he waited for some time and he went away.
Yes, so what can be done?
It may be extended, your lordship,
It
because
will be there in the list on Monday under the heading extension of interim order. Item number 48.
48, your lordship.
Monday, extension of interim order ওপর দিকে তুলে দেবেন। Yes, call the payment of dues matter. Nobody is there. It's better call the hearing matter 2 p.m. fix আছে। Yes. Who is your other side? 215. Did you put the other side on notice?
Yes.
Who is appearing?
My lord,
No.
Mr. Dopain, on the last occasion when this matter was mentioned,
Yes,
upon notice, Mr. Dopain sent, no,
Doipayan Sengupta?
he appeared.
Sengupta? Is it Sengupta? Oh, no. Then,
Earlier, my lord, Mr. Jaya Kumar Gupta was
no, no, he was in the other matter. In this matter, who was?
Mr. Doipan appeared. I was there.
I can see the name of Robindranath Dotto.
Yes,
Robindranath
Rabindranath
Dotto.
Dutta was leading, and
That
there were
was
two
earlier.
other junior advocates, my lord.
That was
And,
earlier.
Robindranath Dotto, Shutanu Chakraborty, and Dipankar Ghosh.
my lord, the notice was given to Dipankar Ghosh, my lord, that it was it to be mentioned. Then he appeared at the time of mentioning.
But then, in the absence of the other side, hearing cannot be done. Serve notice, please. Come.
Yesterday evening, my lord, I have given a call to his clerk that it will be taken up at 2 p.m.
What can be done? See, he's not here.
My lord, I shall give the notice so that.
Come. None appears on behalf of the state respondents. Stop. Let further notice be issued. Next Friday.
Next Friday at 2 p.m.
Yes.
Keep it.
Call the other one.
My lord, just now I have received this much volume of my lord, opposition from the added, my lord, the applicant, my lord.
In Cran 1 and Cran 2.
Why today?
Your Lordship, it was in the order, it was on a returnable date.
It has to be filed on the returnable date. Does it mean that
Your Lordship,
it will be given?
it was a big task for me to get it ready. Your Lordship, kindly.
Let the petitioner make submission. You wait and take notes.
My lord, these things we have not received yet. I'll serve it right away, sir. I'll serve it right away. Today he will serve. This is nothing but a dragging of this operation.
My clerk.
I'm not dragging, sir.
Better, your lordship.
What are all these documents?
Your Lordship, this relates. There are 3 cases pending for which they have come here before the Lordship for quashing.
Yes.
So these are the documents and these are the papers that from day 1 till the Supreme Court, what has been done by the accused person and why the quashing cannot be.
Trial already started. Trial is on since 2013.
No, but then for
my lord.
only for this reason you have prepared such voluminous opposition.
Yes, Your Lordship, because this relates to 3 different cases, Your Lordship.
No, no, it may be 3 cases.
Very shortly.
Yes.
This is for quashing away proceeding of 4 criminal cases. 2 writ applications were filed. Now, my lord's direction, my lord, a compilation was made, which was numbered as CAN 4 of 2024, wherein, my lord, the FIR of 4 cases have been annexed, charge sheets have been annexed, all the points have been jotted down. Now, my lord, for all these 3 cases are concerned, in only 1 case out of 77 witnesses, 2 witnesses have been examined. In other 3 cases, in the 14 years, nothing has been examined. Nobody has been examined. Now, my lord, when a house is built,
this is because of
Do not interject. Somebody is making submission. Please sit down. Please sit down.
When a house is built, a foundation is to be made. Then the rooftop is to be made. And if the foundation, if there is no foundation of the house, then how the case can stand up? But this
Then the case will fall at the trial stage.
No, why trial? The Supreme Court has repeatedly said, and therefore, my lord, your lordship knows it very well. There is Bhajanlal. There are other cases that it cannot go on because it is an abuse of the process of the court. If the man is harassed days after days, that is a different question by way of Article 21 of the Constitution. Now, my lord, we have made short notes of argument as per your lordship request. Very short notes of argument.
Even that has not been served upon us, Your
Why
Lordship.
not?
Notes of arguments are not required to be served.
My lord, we have made it complete. Very short notes of arguments.
Also.
Convenient, we have made it. Now, my lord,
One is a case, the first case is 397, under section 458, 459. But no case has been made out. No case has been made out, even the accompanying document in view of Bhojanal's judgment, the charge sheet, that also does not make out any case. Then, the recent Supreme Court judgments of Pudukas and others matter, the informant, the grounds thereof. That has not been complied with. But the Supreme Court has said, yes, the detention might be illegal, but the entire case cannot go. Therefore, my lord, if the FIR is required, the charge is required. But we have annexed everything in Can 4. We have made it summarized that it does not make out any prima facie case in any of the cases, criminal cases. And that's why a short notes of argument have been prepared. We have prepared the notes of argument.
And with the judgments. These are judgments. All judgments are written there, my lord, with the paragraphs. And these
We
are
want to rely upon only simple paragraphs. I shall tell.
Your lordship,
Now,
we look at the last page of that written notes on the right hand. 5366. Oh, last page and before that. There the judgments has been indicated with the paragraphs.
And these are the references.
Yes. Then fix a date. Next week, any date. I can complete it. And let them kindly direct my learned friend to serve a copy upon us. We can give the between opposition.
Yes, sir.
I didn't buy our learned friend.
There are two sets, I'll explain you, sir.
Therefore, if they say, go on telling every time.
I will prefer to take written notes only after I hear you.
Very well.
Not prior thereto.
Very
So
well.
you can take these back.
Very well.
I can
Very well.
postpone hearing till next week.
Yes, next week, any day.
Friday.
All right.
It means Friday.
I am ready, my lord.
Yes.
They are ready, we shall come back.
Sir,
What is this? This is the opposition.
this is a written notice of argument, your lordship.
Written notes of argument?
Yes, sir.
Sorry, sir. You cannot have such a voluminous written note of argument.
Your lordship-
Absolutely
Your
no.
lordship, this relates to two different applicant, one in CRAN 1 and one in CRAN 2, your lordship. I have made separate, they are separate 2 volumes, your lordship.
Whatever you are exchanging, keep it on that side. Not a single paper will come here, I'll tell you.
Your lordship, but these documents,
No, sir.
These.
The matter will remain in its position, my lord.
Yes, yes, please come.
I'm grateful to receive.
This is not any opposition or reply or nothing. These are all written notes.
Notes of argument, your lordship.
Nothing doing. Absolutely
The matter
no.
needs elaborate hearing.
Your lordship,
There are
because-
4 cases, 2 persons
Yes,
had
sir.
died, my lord.
You are the state.
Yes.
Your responsibility will be to crystallize it to
Yes, my lord.
not more than 5 minutes. No
My
elaborate.
lord, this is such a matter, my lord.
No, no.
There are 4 cases, your lordship, but since 2013, they have been dragging this matter.
1 minute in each
They
case comes to
suppressed
4
material
four
fact before
minutes.
the Supreme Court. They got an order. Thereafter, we moved the Supreme Court before the larger bench, set aside the order,
Further
and
arguments
asked the
next week.
trial court to
Order না করলে পয়সা পাবে না ওরা।
start the